the Honorable, the Chief Justice of the Philippines, and the Associate Justices of the Supreme Court of the Philippines. Hear ye, hear ye, hear ye. All persons having business before the Honorable Supreme Court of the Philippines shall give their attention, for the court is now in session.
You may now be seated.
Clerk of Court.
Your Honors, scheduled for today's oral argument is a petition for the issuance of the writ of kalikasan and the writ of continuing mandamus to prevent and prosecute violations of Philippine environmental laws in Philippine waters and in the Philippine Exclusive Economic Zone, docketed as GR number 246209, entitled MONICO Abogado et al., collectively known as the Kalayaan Palawan Farmers and Fisherfolk Association, Nilo Labrador et al., and the Integrated Bar of the Philippines as petitioners, versus Department of Environment and Natural Resources, represented by Secretary Roy Simato. Department of Agriculture, represented by Secretary Emmanuel Piñol. The Bureau of Fisheries and Aquatic Resources, represented by Director Eduardo Gongona et al. As respondents.
Appearances, please. The petitioner.
For the appearances, Your Honors, Counsel for Petitioners, Attorney Andre Palacios, Attorney Yolanthony Aquino, Attorney Jose Manuel Jokno. Attorneys Palacios and Jokno, Your Honors, will be arguing for the petitioners. For the respondents, we have the Office of the Solicitor General, Solicitor General Jose Calida, Assistant Solicitor General John Emmanuel Madamba, Assistant Solicitor General Rex Bernardo Pascual, Assistant Solicitor General Elaine Rose Sanchez Coro, and Assistant Solicitor General Hermes Ocampo. The Solicitor General, Your Honors, will argue for the respondents.
All right. We will start with the petitioner side. Who will? Attorney Palacios. All right. Thank you. You may sit down.
Thank you.
Attorney Palacios, you may now go to the podium.
Mr. Chief Justice, members of the Supreme Court, may it please the Court. Petitioners today come before the highest court of this land on a matter of transcendental importance involving their constitutional right to a balanced and healthful ecology. The three essential facts which petitioners submit is sufficient to support a grant by this court of the privilege of the writs of kalikasan and continuing mandamus are not disputed by respondents. First, respondents do not dispute that petitioners enjoy the constitutional right. Petitioners include 3 Filipino fishermen from Zambales who used to fish in Panatag Shoal. They include Filipino fishermen from the municipality of Kalayaan, very near Ayungin Shoal and Panganiban Reef. Second, respondents do not dispute that foreigners committed criminal violations of Philippine environmental laws in the Philippine Exclusive Economic Zone. Illegal poaching in Philippine waters, illegal harvest of endangered giant clams and sea turtles, and destruction of Philippine coral reefs were committed in Panatag Shoal in 2012 and Ayungin Shoal in 2013. Dredging and destruction of Philippine coral reefs started in Panganiban Reef as early as 2014. These criminal violations of Philippine environmental laws were observed by respondents and documented by them in official government records, which were later submitted as annexes by the executive branch to the Philippine Memorial in the UNCLOS arbitration. Lastly, Your Honor, respondents do not dispute that the criminal violations resulted to massive environmental damage. The massive environmental damage is documented in the expert report of Professor Carpenter, which is also annexed to the Philippine Memorial submitted by the executive branch in the UNCLOS arbitration. The Philippines is the global epicenter of marine biodiversity. Our coral reefs are the most valuable marine resource. However, they are fragile and highly vulnerable. The damage is of such magnitude as to prejudice the life, health, and property of the inhabitants of Zambales and Palawan, including fishermen petitioners here. The environmental crimes committed by foreigners and the resulting damage to the marine environment constituted violations of the right of petitioners to a balanced and healthful ecology. Petitioners today come before this court because of the unlawful failure or refusal of respondents to prosecute these criminal violations of Philippine environmental laws. Article 2, Section 16 of the Philippine Constitution imposes the duty on the state to protect and advance the right of the people to balanced and healthful ecology. This constitutional duty is operationalized by the Philippine Fisheries Code, which requires the prosecution of all individuals who violate its provisions, whether they be Filipinos or foreigners. The Fisheries Code provides that its provisions shall be enforced in all Philippine waters, including the Philippine Exclusive Economic Zone. It mandates the Bureau of Fisheries and Aquatic Resources to initiate the criminal prosecution of its violations. In their verified return, respondents admit that in 2012, they witnessed the environmental crimes when they boarded the fishing vessels of foreign poachers. However, respondents claim that they were prevented from arresting the poachers because of the presence of foreign government ships. Granting that respondents could not arrest the poachers at sea, respondents should have immediately commenced prosecution against them upon reaching shore by filing an administrative or criminal complaint. The prosecution of foreign poachers would serve as, number one, a vindication of petitioners' constitutional right to a balanced and healthful ecology, and an effective deterrent against future violations by foreign poachers. Petitioners pray that this court grant the privilege of the writs of kalikasan and continuing mandamus to direct respondents to prosecute the criminal violations of Philippine environmental laws and protect the marine environments in the three maritime areas. Petitioners are mindful of the difficult challenges faced by respondents in terms of manpower and resources to enforce our laws in the entire breadth of the Philippine Exclusive Economic Zone. If the court grants the privilege of the writ, respondents can request Congress for a bigger budget so they may comply with the court's directive to protect the three maritime areas. Petitioners are mindful of the foreign relations issues relating to the Philippine Exclusive Economic Zone. However, this case involves the enforcement of domestic environmental law against private individuals. Environmental crimes, when committed by Filipinos, are met with prosecution. The same crimes, when committed by foreigners, should also be met with prosecution, not diplomacy. We use diplomacy to discuss with foreign governments, but we prosecute individuals who continue to violate our laws. If the privilege of the writ of kalikasan is not granted, petitioners will lose the opportunity for a vindication of their constitutional right to a balanced and healthful ecology. If the privilege of the writ of kalikasan is not granted, our country will lose a golden opportunity to take action that would deter future violations of Philippine environmental laws and secure the marine environment, not only for petitioners or for the present generation, but for future generations as well. May it please the court.
Justice Leonin.
I understand if there are procedural issues, it's Attorney Chell. Can I ask Attorney Jokno to take the podium? I will call on you again later, Attorney Palacios.
Good afternoon, Your Honors.
Yes. You agree with me that every time the Constitution is invoked in a petition, it raises into question the existential question of the role of this court vis-a-vis the constitutional order. You would
Yes, Your
agree with
Honor.
me. And that the powers of this court evolve in relation to not only the words that we find in the Constitution, but the contemporary circumstances. Would you agree with me?
As I understand it, the Constitution is a living document, so I would agree with you, Your Honor.
Yes, and specifically that the model or the general pattern of our Constitution, starting from the 1935 Constitution, the American order of three separate branches and a very limited sense of judicial review is now different in the 1987 Constitution. Would you agree with me?
It has evolved, if Your Honor, please.
Yes, because in the 1935 and when in 1776, the Americans were drafting their constitution, which they extended to us through the McKinley Instructions and the 1900s bill, there was still no concern about the environment. Is that not correct?
That is true, Your Honor.
And specifically with the environment, it can be an incremental destruction of our environment, and only suddenly will we realize that there will be a qualitative change of the environment that we have. Isn't that true?
That is correct, Your Honor.
For example, the danger that we face now regarding climate change, which is part of the biggest ecological disaster or catastrophe that we are facing, has been the result of ages and generations of contributions to carbon, methane into our environment. And then only later, like today, we see heat waves hitting Europe, the kinds of temperatures that we suffered. So this is essentially incremental, and then suddenly we just notice the environmental destruction. Isn't that correct?
Yes, Your Honor.
And insofar as the West Philippine Sea is concerned, they did not construct the artificial installations in a day. Neither were the fishers coming from other places that use cyanide, etc. They did not come in droves, but they came in little by little. Is that not correct?
Yes, Your Honor.
And the situation in our country is that the president only has a term of 6 years, barring any constitutional change, of course, but it is definitely 6 years. Members of Congress have a term of 3 years, extendable, and members of the local governments 3 years. Is that not correct?
Yes, Your Honor.
And in terms of the period for environmental disasters, these are very short in relation to the seeing of the effects of an environmental catastrophe. Is that not correct?
Yes, Your Honor.
Yes. So therefore, the only institution that survives perhaps longer than the terms of political officers is this court. Is that not correct?
That is very correct, Your Honor.
And with respect to this court and other courts, like the Court of Appeals, for instance, the Court of Appeals will always be thinking about what the Supreme Court's policy will be. And therefore, it is sometimes there are certain cases that are filed directly with the Supreme Court simply because of its novel, transcendental, complicated, and sensitive content. Is that not correct?
That is correct. In fact, I think that was an observation made by Your Honor in another Kalikasan case.
Yes, in Pahe.
Yes.
But the point there is that there are certain situations where a Court of Appeals, perhaps, or an appellate court or a regional trial court might not feel comfortable dealing with the issue because it needs the, let us say, the inputs of 15 individuals that have given an almost lifetime term to really sit back and think about the epistemic as well as the existential content of those issues. Is that not correct?
I would say the wisdom, Your Honor, of the highest members of the members of the High Court.
Yes, and it's up to the Supreme Court to deal with, for example, what it does with the case and the guidance that it will give to lower courts in case it is remanded or in case they constitute maybe the Court of Appeals as a commissioner to try the facts. Is that not correct?
It is within the authority and jurisdiction of the court, and under the internal rules, the court may in fact delegate reception of evidence to a lower court or to a
Yes.
justice.
Okay. Would you say that this is the type of case that should be tackled first by the Supreme Court and not initially by the Court of Appeals?
Definitely, Your Honor. We submit that we do not present any factual issues in this case.
But of course, the Solicitor General does not agree with you and wants to point out there may not be, let us say for the sake of argument, there may not be certain factual issues in relation to whether there has been ecological destruction in the Ayungin Shoal, the Mischief Reef or the Panganiban Reef, and the Scarborough, right? But certainly there is a factual issue with respect to what government has done. Is that not correct?
Well, if Your Honor, please, when we pored over the verified return submitted by the Solicitor General, it did not appear to controvert any of the allegations that we
For
made.
example, whether or not they indeed declared the area as a protected area, isn't that a factual issue?
Not in our view, if Your Honor, please.
Whether or
The-
not there were actually voyages that looked at that did marine research in order to be able to provide input as to the sustainable yield or whatever modern version it is important. Isn't that also a factual
The
issue?
central issue, Your Honor, that we are bringing before this court is the enforcement of the Fisheries Code environmental laws in the West Philippine Sea.
Yes, but before we
So-
can get to that, we need to determine for ourselves what government has done. And for instance, whether in fact there were actual fishers that were arrested and prosecuted and convicted. Isn't that also a factual issue?
Our petition, if Your Honor, please, alleges facts that took place and that are the subject of the memorial submitted by the Philippine government and of the arbitral award
Yes.
decided by the Permanent
Which-
Court of Arbitration,
Okay, which
took
showed
place.
the existence of environmental destruction in relation to Article 192 of the UNCLOS, definitely, but it did not show whether the government after July 2016 had done nothing, refused or omitted to do anything in relation to such environmental destruction. Would you agree with me?
Yes, when we looked over the verified return, if Your Honor, please, it did not controvert any of the allegations that were part of the submission or memorial of the Philippine government to
Okay.
the Permanent Court of Arbitration.
But let us assume that there are factual issues. Let us just assume that there are, okay, for the sake of argument. Where in the Constitution does it say that the Supreme Court cannot deal with a factual issue? Is there any provision in the Constitution, to your recollection, in Article 8, from Section 1, maybe even Section 5, where it actually says that the court cannot deal with a factual issue?
I am not aware of any. Your Honor.
In fact, it is in Rule 45, which is a rule of this court. Rule 45 says that only with questions of law can it deal with Rule 45. By the way,
That is
counsel,
for appeals by certiorari, Your Honor,
yes,
from the
it
Court
is an
of
appeal
Appeals.
by certiorari. It is not an original petition. And the assumption there is that it has gone through a certain amount of levels of courts before it gets to the Supreme Court. Is that not correct?
Yes, and that is why the doctrine of not disturbing the factual findings of the lower court
Yes.
come into play.
In petitions for habeas corpus, in your experience, and I understand that you have a lot of experience in habeas corpus, has there been situations in the past, even in the 1980s, where the Supreme Court actually dealt with factual issues?
Many cases in terms of habeas corpus where allegations were made by the petitioners that were denied or contradicted by the return of the respondents.
In fact, as a young lawyer, one of the first cases where I assisted your father was in a actual habeas corpus case assigned to a commissioner to deal with the facts of the case, and that commissioner was a regional trial court judge in Quezon City.
Yes, Your
who-
Honor. I
yes.
also recall a case where the court delegated to the physician of the Supreme Court and two other doctors the examination of the petitioners in terms of allegation of torture.
Okay. The Supreme Court sits as the Presidential Electoral Tribunal. Is that not correct?
Yes, Your Honor.
Yes. And the PET deals with factual issues. Is that not correct?
Yes, Your Honor.
In fact, we have actually about, if I'm not mistaken, and if Justice Kagiwa will correct me in the future, we have about 50 revision tables which have already done their part in revision. We have a group of 3 commissioners to look at the appreciation of the interpretation of the ballots. We have preliminary appreciation committees to help the court deal with the factual issues in that case. Is that not correct?
Yes, Your Honor.
And in the cases of habeas corpus and PET, some habeas corpus cases, not all, it may be of such a quality of a controversy where the Supreme Court wants to maintain its jurisdiction in order to, perhaps because it is novel, provide guidance to lower courts on how to deal with future cases of a similar import. Is that not correct?
Yes, Your Honor.
Yes. Now, there is this new case of Gio Samar. And one of the reasons why hierarchy of courts is to be respected is principally to do the filtering before it goes to the court. Is that not correct?
Yes, Your Honor. I'm familiar
Yes.
with that case.
Yes, but would you know what types of cases go to the Supreme Court in bulk? Aren't these 45 cases, but not Rule 65 cases, or even the extraordinary jurisdiction of the court?
Well, I do not have the data in my possession, but I would imagine that there would be more
Well, just to be clear,
appeals.
Cases reach the court through Rule 45, that is by appeal. Automatic appeals coming from the regional trial courts in relation, and the Court of Appeals in relation to penalties involving life imprisonment and reclusion perpetua, correct? And of course, there is the original petition of 65, the special proceedings of habeas corpus, amparo, etc., and many others. Is that not correct?
That is
Yes.
correct, Your Honor.
Now, the Supreme Court can have original jurisdiction for some of these cases, even if it is at first instance because of the importance of that case. Isn't that true?
There is much precedent to support that, Your Honor.
Yes. And therefore, when we filter cases in order to reduce the docket of the court so that we can focus on the important issues, we must be careful not to filter the important issues. Is that not correct?
I believe that is why we have the doctrine of transcendental importance.
Yes,
Your Honor.
and
Yes.
if we do that, we filter all the cases, even the transcendentally important ones, we weaken the ability of this court to immediately address questions where the public wants a statement on the rule of law or the interpretation of law at that moment. Is that not correct?
That is correct, Your Honor.
Yes, and when we weaken the Supreme Court's powers, then we weaken the rule of law. Would you agree with me?
Yes, Your Honor.
Yes. Anyway, I am sure that some of my colleagues will ask more interrogative questions on the issues of fact that you may have raised in your petition. So I will go on to the next procedural objection. Can a decision of this court affect foreign policy? In other
Yes.
words, is it beyond the jurisdiction of the courts, this Supreme Court, to rule on a legal issue simply because it has an impact on foreign policy?
No, it's still within the jurisdiction of the court to do so, Your Honor.
Yes. For so long as this court does not dictate what foreign policy will be. Is that not correct?
Or interfere in the wisdom of the executive's judgment.
Yes. But certainly, even the president who conducts foreign affairs may be in a privileged and primary manner has to deal with the Constitution. Is that not correct?
That has been the import of several decisions of this honorable court.
In other words, the president, when dealing with other countries, is limited by the Constitution. Is that not correct?
He may not violate himself the Constitution
Yes.
in his foreign relations. Yes.
And the Constitution, as far as any public officer is concerned, is an important piece of paper. It is not a senseless document. Is that not correct?
Definitely, most
Yes.
definitely, Your Honor.
So it becomes senseless only if we do not interpret it correctly. It becomes senseless if we do not invoke it with the judiciary. But it is important that at certain times the Supreme Court speaks on the limitations for the conduct of foreign policy. Is that not correct?
In fact, in the Constitution, if I may add, Your Honor, the faithful execution clause imposes an obligation on the chief executive to faithfully execute
In
the
other words,
Constitution
even
and
the
laws.
head of state, the president, is not above the Constitution. Is that
Yes,
not
Your
correct?
Honor.
Okay. And the Constitution actually says in Article 2, Section 1, I hope maybe some PowerPoint will be put there, that the Philippines is a democratic and republican state. All governmental authority emanates from the people speaking through the Constitution. Is that not correct?
That is correct.
Yes. And in Article 2, it actually says that we also follow the policy of general principles of law, of international law, becoming part of the law of the land. Is that not correct?
Yes, Your Honor.
And I think it will be important in this case that it also says we adhere to a policy of peace, equality, justice, freedom, cooperation, and amity with all nations. Is that not correct?
That is part of the Constitution, yes.
What does amity mean?
It means cooperation with other
Yes.
states.
Does it mean friendship?
It could perhaps extend to that
Yes.
as long as it does not violate any constitutional provisions.
So there is a provision in the Constitution that says friend, amity, correct?
Yes, Your Honor.
Yes, but that is not the only provision in the Constitution. We go to Section 3. And Section 3 is, I think, very important. The armed forces of the Philippines is the protector of the people and the state. Its goal is to protect, to secure the sovereignty of the state and the integrity of national territory. Is this a foreign policy provision?
No, Your Honor, that is a
I think it is
obligation.
because it says national territory. To define national territory and to protect it means where you send your Navy and Coast Guard in order to set the boundaries of your state. Is that not correct?
Yes, that is
Yes.
defined by Philippine law in the Constitution
Yes.
itself.
And if you look at Section 7 of Article 2, it actually says that the paramount consideration for foreign policy is national sovereignty, territorial integrity, national interest, and the right to self-determination. There is territorial integrity there too, correct?
Those are the main
Yes.
limitations imposed by the Constitution, Your Honor.
Okay. The president is faced with many problems because he is the president, or she will be, she in the future maybe, I don't know, is the president, correct? And these issues are very complex. And certainly, it will help if Congress weighs in and the judiciary also weighs in insofar as their competence is concerned. Is that not
That
correct?
is correct, Your Honor.
And that is not something to be angry about. That is something to accept and perhaps tolerate and perhaps even welcome, because then many heads will be able to contribute to ideas in order to solve a particular problem. Is that not correct?
Yes, Your Honor.
And our problem with the West Philippine Sea, actually the problem given to us by others in the West Philippine Sea is a very complex one, correct?
Yes.
It is in fact the Achilles heel of many administrations. Is that not correct?
We could be, yes, Your Honor.
Having spoken and dealt with many Westcom generals, these are generals assigned to that sector, their greatest fear is when there is a conflict in the West Philippine Sea, because they know that our resources are limited. And therefore, it might help that the judiciary will also weigh in within its sphere of competence. Is that not correct?
That is true, Your Honor.
Now, would you know if there has been any Senate investigation on the implementation of the arbitral award?
As far as I know, there has not been
What
any.
about the House? Has there been an implementation?
To my knowledge, Your Honor, none.
And insofar as the Supreme Court is concerned, is this the first case that deals with the arbitral award?
I believe this is the case of first impression.
Yes. Okay. I'll go to other procedural issues. Again, I think my colleagues have lots of questions in relation to the foreign policy angle. You did not include the fishers in your respondents, specifically the fishers that cause, that do cyanide fishing, dynamite fishing. You did not include whoever installed the artificial installation in the Mischief Reef, correct?
No, we did not include them, Your Honor.
Why is that?
First, insofar as the fishers are concerned, we do not have the information necessary to implead them. We do not even know
Are
their...
all the indispensable parties therefore impleaded in your petition?
I believe so, if Your Honor, please. Yes.
But when we examine it, it is only the government that is impleaded, down to the Coast Guard commander, correct?
Because our theory of the case, Your Honor, is that this is about enforcement of Philippine laws by agencies of government.
Okay. Perhaps you'll cover that more, whether or not your case is dismissible on the ground of the lack of indispensable parties, or whether the actual fishers that do dynamite fishing, as well as whoever maintains the artificial installation in Mischief Reef, as well as the ships that actually surround the Ayungin Shoal, making it impossible to resupply the 8 or 10 Marines, I'm not sure, in the BRP Sierra Madre, impossible. Would you please cover that in your memoranda?
Yes, Your Honor. We will
Okay,
do that.
now, in terms of the rules on cases involving the environment, would you agree with me that there are 3 parts? The first part dealing with civil, criminal, and administrative cases involving the environment. The second part dealing with the special proceeding called the writ of kalikasan. And the third part dealing with a special civil action called continuing mandamus.
Yes, Your Honor.
And in relation to all of this, what is the unique situation for a writ of kalikasan?
Well, damage, the magnitude of the damage should be such as to prejudice the inhabitants of 2 or more cities or provinces.
Okay, just to be clear, for the first part, in terms of civil actions, there can be TEPOs and EPOs, temporary environmental protection orders and environmental protection orders, correct?
Yes, Your Honor.
For the special proceeding called the petition for a writ of kalikasan, there is also the issuance of a writ of kalikasan. This is different from a TEPO or an EPO, correct?
Yes, Your Honor.
In fact, when we issued the writ of kalikasan, you did not yet get any affirmative relief, except for the Solicitor General on behalf of the respondent government agencies to actually file a return, correct?
That is correct.
It's a very similar structure to a petition for a writ of habeas corpus, correct?
Yes, Your Honor.
Which is a special proceeding.
Yes, Your Honor.
Right? And therefore, the most important function of a writ of habeas corpus, similar to that a writ of kalikasan, is for government to reveal certain facts which the petitioners may not know. Is that not correct?
That is true, Your Honor.
As in writ of habeas corpus, for government to reveal whether or not a person is in fact detained and the reasons for the detention, correct?
Yes, Your Honor.
For a writ of kalikasan, whether in fact there is an environmental catastrophe of such magnitude and what government is doing if it is the respondent. Is that not correct?
That is true, Your Honor.
And the court then will deal based on the submissions of the parties as to what its final orders are in terms of these special proceedings. Is that not correct?
Yes, Your Honor.
In petition for habeas corpus, whether to order the release or to simply dismiss the entire petition. Is that not correct?
That is true, Your Honor.
Yes. So there is a difference between the writ of habeas corpus and the order from the petition for habeas corpus. Is that not correct?
Yes, Your Honor.
As we issued the writ of kalikasan, but you haven't won the case.
No, Your Honor.
The issue here is whether we can put certain affirmative reliefs, if there are any, within our jurisdiction in a final order. Is that not correct?
The issuance of the writ upon filing of the petition is a ministerial act if the petition is sufficient in
Yes.
form and substance. It is up to the court to grant the privilege of the writ in its judgment.
The other procedure is continuing mandamus, which you also invoke, which
Yes,
is a
sir.
special civil action.
Yes, Your Honor.
Yes. And in the writ of continuing mandamus, the affirmative relief is an act or a series of acts to government in order to accomplish certain things, correct?
Yes, Your Honor.
Such as, for instance, to clean up Manila Bay, correct?
Yes, Your Honor.
Wouldn't you think that this, in fact, infringes upon the executive prerogative to supervise all the agencies that are supposed to clean up Manila Bay, for example?
I do not think it has any conflict there because after all, the primary obligation of the chief executive and his department is to observe the faithful execution of the laws, which would include environmental laws.
But by issuing a writ of continuing mandamus for your case, wouldn't we be supervising what government does on a daily basis? Because they will be asked to report maybe on a quarterly or semi-annual basis, and therefore replacing ourselves, 15 in a collegiate body, skilled in terms of interpreting the law, but not dealing with contingent circumstances, replacing ourselves with the executive.
I do not think that this honorable court would have to go into the minutiae or the details of its judgment. The reports would simply show whether the respondent is complying with the judgment of the court.
Yes, I hope you will cover in your memoranda that line as to where the writ of continuing mandamus, which you are asking, or the writ of kalikasan will traverse and therefore bring this court into an executive function of which we are not competent. Dealing with, of course, the unique nature of the environment and the concept of writ of kalikasan. By the way, Counsel, I understand that you've studied abroad. Is
Yes,
there a
sir.
writ of kalikasan in the United States?
Not that I know of, Your
Yes.
Honor.
Is there a writ of kalikasan anywhere else in the world?
To the best of my knowledge, there is none.
So this is a unique thing that the court is dealing with. And
Yes, sir.
therefore, to a certain extent, we are defining a new remedy for the environment. Is that not correct?
Yes, it's
And
very
given climate
groundbreaking.
change, given the catastrophe that we are awaiting, by 2040, if we do nothing, we will reach 1.5 degrees centigrade increase in the average temperature of the globe. And by that time, disasters will become catastrophes. 2040, and by that time, we will still be alive. Correct? And
Yes, sir.
our children will reach middle age, 30s or 40s. Is that not correct?
That's
And therefore, you have to, maybe in your memoranda, clarify where the writ of kalikasan and the continuing mandamus stops, insofar as this court is concerned. When is it not within our province? But there is guidance in Rule 7, Section 1. This is in the issue on the rule on writ of kalikasan. It says here the cause of action is a constitutional right based on the constitutional right to a balanced and healthful ecology. That is the right. The breach is violated or threatened with violation by an unlawful act or omission, and it should involve a damage of such magnitude and prejudice to life, health, and property of inhabitants affecting 2 or more cities or provinces. Is that not correct?
Yes, Your Honor.
Yes. Let's look at the magnitude first. The magnitude is both breadth and depth, correct?
Yes, Your
Breadth
Honor.
in terms of the number of provinces affected, depth in terms of the catastrophe that it is affecting. Would you say that this is applicable in your case?
Yes, Your Honor. We are talking about only one body of water when I refer to both the West Philippine Sea and the waters within the Philippine archipelago. We know that the ecological system in an ocean is very much interconnected and very much interdependent. So that damage, for example, to the reefs within the Spratly Islands could very well affect the seas that our fisher folk fish in.
Not only ours, but the common heritage of mankind,
Yes.
because do fish have passports, by the way?
No, Your Honor.
No, and you will never know whether a fish is Chinese or Taiwanese or Vietnamese. Is that not correct?
That is correct. Your
Yes, probably all of them are Filipinos, right? Maybe some of them are orphans, and therefore natural-born Filipino citizens. No, just kidding. The most important portion where your petition may be problematic is the allegation of violated or threatened with violation by an unlawful act or omission. Okay. Are you alleging an unlawful act done by the respondents? Have they
Omission.
done an unlawful act?
Unlawful omission, if Your Honor, please.
No, unlawful act. Dolo.
No,
Meaning
Your
to say, not unlawful act. So you're alleging an omission. Is that not
Yes,
correct?
Your Honor.
And that omission, as I have said, can be factual in nature, correct?
It could be.
And the omission that you're saying is what kind of omission? I mean, what are the things which they should have done that they have not done?
Unjustified neglect, Your Honor, in enforcing the environmental laws. For example, that up to now, we do not have, our government does not have even the vessels to do proper monitoring
Okay.
in the affected areas.
So in your view, for so long as the artificial installation in Mischief Reef is there, for so long as our fishers cannot fish, even using traditional artisanal means, according to the arbitral award in Ayungin as well as in Scarborough, there is neglect on the part of the respondents.
Yes, Your Honor.
Even though that is a very complex matter, even though it may not take 3 years, because that's from 2016, it's now 2019. It may take incremental actions, diplomatic moves, certain kinds of negotiations, allocations in the budget, in order to be able to accomplish the end that you wish.
As far as the agreements between states are concerned, that is correct, Your Honor. But as far as individual violations by private fishers, nationals of other countries within our seas, that is subject of enforcement by our agencies.
Or is this a matter of whether the respondents have taken acts in good faith, which they believe, insofar as reasonability is concerned, will lead to the result of actually helping our fishers and preserving that environment? It is not necessary that this court will actually see the removal of the environmental destruction or the ecological disaster.
It does not have to reach that far, yes, Your Honor.
Okay. Perhaps in your memoranda, you are going to detail for us what exactly would you want an order coming from this court to contain. And I hope that you will take into consideration that we are not Congress and we are not the executive in order for us to be able to do this. Continuing mandamus, the other rule that you invoke, requires that there is an unlawful neglect to perform an act. And what is that unlawful neglect? What law have they violated?
Well, one, of course, Your Honor, is the provisions of the Fisheries Code that provide that the mere presence of a foreign fishing vessel within our waters creates a presumption that they are engaged in poaching.
Again, I hope that you can cover that more and explain it clearer, because certainly the fact that we have a lot of murderers still out there doesn't mean that our police is not doing their best in order to reduce the crime, correct? The fact that there are many people that still take property which are not theirs doesn't mean that there is neglect of duty, correct? And the fact that there are illegal poachers that are found within our exclusive economic zone, that's 200 nautical miles, doesn't necessarily mean that they are neglectful, correct?
Well, if I may make the same analogy, Your Honor, the fact that the police, Philippine National Police, would not even have the motor vehicles necessary to go after their criminals would, I think, constitute neglect. And in this particular case, there are admissions made in the return itself, in the annexes, that the government agencies do not even have the vessels to make it to the shoal or to the reef.
How many vessels would you want this court to order purchased?
Well, at the very least, there must be a clear plan on the part of the government, concrete proposals to acquire those ships. Because otherwise, the laws that we have would simply be paper laws that
Yes,
would be
but
impossible
counsel,
for...
how will the court know whether the plan is sufficient? In other words, do we need to measure our coastline, and what is the ratio of a vessel to our coastline?
I do not think we would have to go that far.
Okay, again, please cover that in your memoranda, because we want to know specifically what the affirmative reliefs are, if any, that you think the court has jurisdiction to issue. By the way, the allegation is you did not meet a condition precedent found in Section 138C of Republic Act 8550 as amended by 10654. What do you say to that, counsel?
Section 138 refers to citizen suits that is covered by Part 1 of the RPEC, if Your Honor, please. That is not covered by Part 2 or Part 3 on the writ of kalikasan or the writ of continuing mandamus.
Yes.
It's our position that it's not required for writs of kalikasan or mandamus.
Is it your claim that you have substantially verified your petition?
Yes, Your Honor.
You can be interrogated on that later by maybe my colleagues. And the other thing is, there are no judicial affidavits attached to your petition for a writ of kalikasan. Would you stipulate to that? There are no judicial affidavits.
That is true. However, if you look at the rule carefully, if Your Honor, please, there is no requirement of judicial affidavits. In fact, in one of the decisions of this court, that distinction was made between the submission of evidence and the submission of judicial affidavits. We submit that the Philippine Memorial as well as the arbitral award, which came from the government itself, constitute the facts of the case, and there really is no factual dispute as far as the destruction to the environment, the incidents that are alleged therein.
Okay. Thank you, counsel. Please cover some of the points in your memoranda. May I ask Attorney Palacios to take the podium
We'll do
for
that, Your Honor.
for some brief questions. Let's look at the substantive part, and just so we can locate ourselves very clearly. We are talking about only 3 features of the West Philippine Sea. Is that not correct?
Yes, Your Honor.
Yes, and these three features let us use two names, the English and the Filipino names. So we have Mischief Reef, otherwise known as the Panganiban Reef. We have the Second Thomas Shoal, which is otherwise known as Ayungin, and we have the Scarborough Shoal, which is otherwise known as the Panatag Shoal. Yes, and I will show you a map where they are located. Okay, and so we find Ayungin and Panganiban, Mischief, and the Second Thomas Shoal very close to Palawan, and the other one is in Scarborough, which is very close to Zambales. Is that not correct?
Yes, Your Honor.
Are you claiming that because they are found close to two provinces, the petition for writ of kalikasan's requirement as to the magnitude, the breadth, is already covered?
Not necessarily, Your Honor. The petitioners are residents of those provinces, and we're not referring to the location where the massive damage occurred.
Yes, and you are actually saying that because it affects the entire sea, because this is a marine biodiverse area, then therefore it is important that we cover this and consider this as within your petition for writ of writ of kalikasan. Is that not correct?
Yes, Your Honor. If I may be allowed, Your Honor, to read from Annex 240
Yes,
of the Annex to the
maybe
Memorial.
later, just to be clear. Okay. Just so we're clear as to where these are, what these features are in relation to our territory. Panganiban and Ayungin Shoal are low tide elevations. Is that not correct?
Yes, Your Honor.
And Panatag Shoal is a rock,
Yes, Your
meaning
Honor.
to say a high tide elevation.
Yes, Your Honor.
Correct?
High tide feature, Your Honor.
High tide feature, but it does not have the ability to sustain human habitation in its naturally occurring state, and therefore it has no capacity to create its exclusive economic zone. Correct?
Yes, Your Honor.
And as far as the Philippines is concerned, are all of this within the the territorial sea of the Philippines?
They are within the Philippine Exclusive Economic Zone, Your
Not
Honor.
within the territorial sea,
Not
correct?
necessarily within the territorial sea, Your Honor.
Insofar as Panganiban and Ayungin Shoal is concerned, what did the arbitral award say? Insofar as their relation to our exclusive economic zone.
Yes. The Arbitral Tribunal, Your Honor, categorically stated that Ayungin Shoal and the Panganiban Reef are within the Philippine Exclusive Economic Zone.
Okay, let's deal with that. The conclusions of the arbitral tribunal is an arbitral award. It is an international decision, although of a different kind. It is by arbitration. What is the relation of that finding to the Philippines, specifically to the judicial component of our constitutional order?
Yes, Your Honor. It's not very clear, Your Honor, as to the legal effect of an arbitral award under Philippine legal system. We follow the dualist approach as described by Justice Brion in Poe versus Comelec.
But Justice Brion is no longer with us.
Yes, Your Honor.
Yes.
But he was talking about the dualist approach, Your
Yes.
Honor, where the law operates under two planes. And so, Your Honor, what is the effect? We can liken it, Your Honor, to one of the enumeration in Article 38, Paragraph 1 of the Statute of the International Court of Justice, which Article 30, Paragraph 1, which has a subparagraph D, refers to judicial decisions as a subsidiary means for the determination of the rules of law. I know, Your Honor, that an arbitral award is not similar to a judicial decision, but that's the nearest that we can have for an arbitral award, Your Honor.
In other words, can we, by interpretation, overturn the findings of an arbitral award? Specifically, this finding, can this court say that Panganiban Reef and Ayungin Shoal are not part of our EEZ? Or will we be impeached if we do that?
I guess I would respond with 2 points, Your Honor. First of all, that may involve a question of fact. And I don't know if the Supreme Court is willing to wade into issues of fact. And second, Your Honor, the Supreme Court decision would operate within the Philippine legal system, whereas the arbitral award operates under the international legal system.
Wasn't the arbitration brought by the Philippine government?
Yes, it was, Your Honor, under
Yes.
the international
and
legal
because
system.
it was brought by the Philippine government, it committed to the international community under the dispute settlement process of the UNCLOS, which it signed and ratified. It committed that it was going to comply with it in good faith. Is that not correct?
Yes, Your Honor.
And because of that commitment under international law, would you say that we should take judicial notice of that finding that Panganiban and Ayungin is within our EEZ?
Yes, Your Honor. Not only should the Supreme Court take judicial notice of the International Arbitral Award, it should also take judicial notice of the official acts of the executive branch in submitting the Philippine Memorial, which alleged and argued that, in fact, the Ayungin Shoal and Panganiban Reef are within the Philippine Exclusive Economic Zone.
Okay. This is preliminary to questions on ecology, which I will go back later. But with respect to Panatag Shoal, did the arbitral award actually say that it is within our exclusive economic zone?
Your Honor, the International Arbitral Tribunal did not declare that Panatag Shoal
Did
is
it also
within...
declare that it is not within our EEZ?
Well, they referred to it as traditional fishing grounds, Your Honor. They declined...
That's different. Did it actually say that it is not within our EEZ?
They declined to make a
They
categorical
declined to make a
statement, yes.
categorical statement because they said that they were not competent because of the reservation of China in terms of its ratification of UNCLOS to rule on maritime delineation and sovereignty questions, correct?
Yes, Your Honor.
And certainly, if this was a land area, then UNCLOS, in fact, will not even have any say. But it did say that Panganiban and Ayungin are within our EEZ because there is no other feature that can generate an EEZ contrary to ours, correct?
Yes, Your Honor.
And in fact, it said that the 9-dash line is an invalid, illegal, in terms of the treaty, way of delimiting maritime entitlements. Is that not correct?
Yes, Your Honor.
Yes. So, with respect to Panatag Shoal, Scarborough, it said nothing about whether it's within our EEZ, correct?
Yes, Your Honor.
So we have to refer to our laws.
That's right, Your Honor.
Does our law consider it as within our EEZ?
Presidential Decree 1599, Your Honor, states that the Philippine Exclusive Economic Zone extends up to 200 nautical miles of the Philippine baselines, and Panatag Shoal, Your Honor, is about 196 nautical miles from our baseline. Second law, Your Honor, is the Philippine Baselines Law of 2009, where it categorically states that the Kalayaan Island Group, as well as Scarborough Shoal, are areas over which the Philippines has sovereignty and jurisdiction.
Okay. The EEZ was a conception of UNCLOS. Is that not correct?
Yes, Your Honor.
Yes. And in fact, it was in the third negotiations for the UNCLOS. Am I not correct?
Yes, Your Honor.
Yes. There were two initial UN-sponsored conferences to try to come out with a law of the sea, but it was in the third that this was actually formulated as a compromise, correct?
Yes, Your Honor.
This was the third UNCLOS, which started in 1973 and ended in 1982.
Yes, Your Honor.
What was China's position in terms of the EEZ?
Your Honor, China, with regard to the position of China in the negotiation of the UNCLOS, Your Honor, I'm not aware.
It was in fact the one that actually argued hardest in giving exclusivity to certain sovereign rights within the EEZ. Is that not correct?
I see, Your Honor.
And it is now found in Article 56 of the UNCLOS, correct?
Yes, Your Honor.
That whoever has an EEZ has the exclusive right to explore, exploit, conserve, and manage living and non-living resources, correct?
Yes, Your Honor.
And then there is even a subparagraph which says it is the only entity that can build an artificial installation. Is that
Yes,
not
Your Honor.
correct?
Can authorize the
Yes.
construction of
As
artificial
a matter of
islands,
fact, there is where the arbitral award said that the artificial installations found in Panganiban and Ayungin were illegally constructed. Was there a definite finding there? Yes, there was, correct? In the arbitral award, it said that the artificial installations were put up illegally because
Yes.
it interfered with the sovereign rights of the coastal state. Okay, now, if this court or if anybody within our country says that the Panatag Shoal, the Scarborough Shoal, is not part of our EEZ, is that a violation of law?
Yes, it would be, Your Honor.
If there is any official that treats it as if it were not part of the EEZ, would that be an unlawful act
Yes, Your
in
Honor.
terms of the writ of kalikasan and the writ of continuing mandamus?
It's not covered, Your Honor, by the petition. But however, yes, if a statement would be made regarding Scarborough Shoal that it's not part of the Philippine Exclusive Economic Zone, it would violate the provisions of PD 1599, which says that the Philippine Exclusive Economic Zone
Okay.
extends up to 200 nautical miles.
Now, we go to ecological damage, ecological destruction. There was a finding of ecological destruction in terms of the arbitral award, correct?
Yes, Your Honor.
Yes, but its center was Article 192. Its textual anchor was Article 192, which is a general obligation on the part of all states to protect and conserve the marine environment. That was very clear, correct?
Yes, Your Honor.
It
Yes,
has
Your
no relation at all to whether you own that particular area. In fact, it is applicable not only to the territorial sea, but also to the exclusive economic zone, the continental shelf, the area, and the international waters,
Yes, Your
correct?
Honor. Yes, Your Honor.
Just so we have a graphic, I'll just show you the maritime zones. Maritime zones in terms of the UNCLOS. This is for the Philippines, but for the UNCLOS. Yung drawing na may continental shelf. Where is my assistant? Okay? Not that one, the other one. Yung territorial sea, the one with the area. Nasaan na yun? Okay, but in any case, therefore, in relation to any part of the seas, regardless, it is the state's obligation to protect and to prevent environmental disasters, correct?
Yes, Your Honor.
Yes. So that applies not only to China, but to ourselves, correct?
Yes, Your Honor. It
And
all-
because there is such an obligation, very clear, it means that becomes part of the law of the land via Article 7, Section 21, correct?
Yes, Your Honor.
And if it is in fact customary international law, it can even be part via Article 2, Section 2, correct?
Yes, Your Honor.
So a double track in order that it becomes part of our obligations. That it is the obligation of government to prevent as well as to protect marine environment, correct?
Yes, Your Honor.
Now, can that be the legal basis for your claim that this government has not complied with its legal obligations?
Your Honor, it could be one of the possible legal bases for this petition.
But
However,
there
we
is
have
there is no specific thing that it should be doing.
Yes. However, in our petition, Your Honor, we have requested for, we have alleged very specific omissions by the respondents, which include, Your Honor, the omission to prosecute the violations which happened in 2012, 2013, and 2014, Your Honor.
Yes. By the way, isn't the writ of kalikasan and continuing mandamus applicable only for environmental catastrophes that are about to come with such imminence that the court needs to step in to prevent it?
I think, Your Honor, it applies to all situations which involve damage, which result in prejudice to the health, life, and
The
property.
wording is actual or imminent, correct?
Yes.
And as of now, would you say that the artificial islands are still there?
Yes, Your Honor. The,
Would you say that the
destruction,
environmental destruction is still there?
it is continuing, Your Honor.
Why is it that you have no affidavit or proof that anything happened from 2016 to 2019 in relation to ecological damage? Your entire set
yes.
of annexes refer to everything before, inclusive of 2016, but
Yes, Your
there's
Honor.
nothing after.
Yes, Your Honor. We relied on the submissions of the executive branch based on our submission that these are official acts of the executive branch and therefore matters of judicial notice on the part of the court. So that therefore there are no factual issues before this court, rather there are only legal issues.
Will you please cover that also in your
Yes, Your
memoranda? Okay. Does this mean that when we assert our rights under the law of the sea with respect to our maritime zones, that if there is a foreign country that will be affected, when we assert and claim our rights, that war will necessarily come?
I don't think so, Your Honor.
Yes. And as a matter of fact, there have been a lot of other cases, like the Arctic Sunset case. This was against Russia. And this was also with respect to an aspect of their rights in their exclusive economic zone, where Russia, in fact, actually complied with the UNCLOS, albeit not directly because of the award, but they changed their legislation or their domestic situation in order to comply, correct?
Yes, Your Honor.
And on an everyday basis, countries assert their rights and claims via various tribunals, the WTO, the Philippine, the PCA, the ICJ, and so on and so forth. Is that not correct?
Yes, Your Honor.
Yes. And the antithesis of war is law, correct?
Yes, Your Honor.
And barring our ability to send very sophisticated navies, we send our lawyers, correct?
Yes, Your Honor. That's
Because
what we did, Your
our-
Honor, in the arbitral proceedings, Your
Like
Honor.
in the arbitral proceedings. And in this particular case, perhaps it is important and might assist government that this court lays down the minimum that will be required in order to comply with all our obligations. Is that not correct?
Yes, Your Honor.
Yes, but we certainly we cannot tell Congress the number of ships that they should procure, correct?
Yes, Your Honor.
Because that would be too much interference into legislation. And certainly we cannot be an overwatch over the executive, watching them as they try to implement and comply with our obligations, correct?
Yes, Your Honor.
There has to be a balance somewhere.
Yes,
Could
Your
that
Honor.
balance be to dismiss your petition and allow the political departments to simply do their job?
I think, Your Honor, it should be in favor of granting the privilege of the writ and requiring the respondents to file the criminal and administrative complaints against the violators of the fisheries
Should we
code provisions.
assume that the Congress and the executive will not do their jobs?
The respondents, Your Honor, have not done their job of prosecuting administratively or criminally the violators of the 2012, 2013, and 2015
That's your
violations,
allegation
Honor.
in your
Yes, Your
petition?
Honor.
Okay, thank you.
Justice Peralta.
Okay, thank you, Chief. Some of the questions that I was thinking of asking you have already been asked by Justice Lonen, no? So I will just ask you some clarificatory questions. Well, one is that there is an admission from you that there are no judicial affidavits or competent evidence attached to your petition.
Yes, Your Honor, we're invoking the rules of court on mandatory judicial notice,
Yeah.
where the court will take judicial notice without the requirement of submission of evidence, Your Honor.
Yeah. But it is clear from the special rule that the petition must be accompanied by judicial affidavits. The reason why we require that is that in all writs of kalikasan, when we were drafting these rules, all the issues that will be raised are factual. That's why we require the submission of judicial affidavit and competent evidence. Now, if the facts that you allege are disputed by the Solicitor General, can we resolve your petition? Just merely saying that you are using the evidence submitted in the arbitral proceedings pertaining to the acts allegedly committed in the years 2012, 2013, and 2014?
Yes. Well, Your Honor, the court may want to look at those submissions by the executive branch, which actually are matters of mandatory judicial
Yeah.
notice. And
Yeah, the reason why we require judicial affidavit is that so that the opposing party can cross-examine the person who alleged that an illegal act was committed. Without the judicial affidavit, which will be the direct testimony of the witness, we cannot test the credibility of the affiant, because as I said a while ago, we anticipated that all writs of kalikasan will involve factual issues, because you just look at the elements, no? Acts complained of. You have to establish what are the acts complained of, and then the respondent in their answer or in the return of the writ must likewise submit judicial affidavits and then indicate their defenses. So how can we resolve this petition without judicial affidavits on the part of the petitioners and also judicial affidavits on the part of the respondents?
yes, Your Honor, I think this case presents a unique opportunity for the court to examine a situation where where the essential facts which can support the grant of the privilege of the writ.
To me, that's my problem. Because what you're saying is that the facts are not disputed.
Yes, sir.
Because the evidence submitted in the arbitral proceedings, there are already admissions, no? Because they attach some evidence in support of the proceedings.
Yes,
now, if we do that, if we accept that, then in effect, we are enforcing the arbitral tribunal. These were evidence introduced in the arbitral proceedings. And then we've used that, then in effect, you are using the writ of kalikasan in order to enforce
Your Honor, please.
the decision of the International Court.
Your Honor, please. Well, whatever the outcome, Your Honor, of the arbitration proceeding, in this case, we are fortunate that the arbitration resulted in our favor. But whatever the outcome, Your Honor, of the arbitration proceedings, the submissions by the Republic of the Philippines, led by the executive branch, still constitute the official acts of the executive
Yeah,
branch.
but this were evidence not for the purpose of enforcing an environmental right. The purpose of that was to enforce our jurisdiction over the 200 nautical mile zone. So it's not intended to support a petition for a writ of kalikasan.
If Your Honor, please. Yes, that was the intention, Your Honor, of the Philippine government to assert Philippine rights over the Philippine Exclusive Economic Zone, as well as to hold China liable for its international obligations, whereas the purpose of the writ of kalikasan is different. It's merely to enforce domestic laws, which were violated by foreign nationals, and the refusal of respondents to prosecute the criminal violations of those foreigners. But however, Your Honor, we don't think that it is an implementation of the arbitral award. Rather, we are just merely using the submissions of the executive branch.
Okay, I'll go to another point. You put that in your memorandum.
Yes, Your Honor.
My other concern is this, no? The acts complained of, no, not only against the public officials, no, but also other persons, because you have to implicate the other persons who are violating our environmental law. To me, these are indispensable parties. If we issue a privilege of the writ of will it be sufficient just to address them to the public official? Is it not that we have also to address those who are violating our environmental rights?
We believe, Your Honor, that we have impleaded the necessary parties for this case, and that we do not have to implead the private individuals who violated the Philippine environmental laws. They, Your Honor, are subject of criminal or administrative prosecution by the public respondents.
Probably that will fall under continuing mandamos. The writ of kalikasan is to stop the parties from violating our environment. If it is the public official that is violating our environmental right, then they can be the subject of writ of kalikasan. Because the respondents here are public officials.
Yes, Your Honor.
Who are supposed to enforce our environmental laws. Sa continuing mandamos yan.
Yes,
The
Your Honor.
writ of kalikasan is actually addressed to those who are violating, not to those who do not enforce the environmental law. That's why probably you filed 2 petitions in one petition. You put writ of kalikasan and the writ of mandamos, because if writ of kalikasan is not proper, then probably writ of mandamos will substitute or will be the alternative resolution to your petitions. Is it not?
Yes, Your Honor, if I may respond, we are looking at the rules of writ of kalikasan, Rule 7, and in the section on the reliefs available to the parties, one of the reliefs, number 1, the first relief that's available to the party is a directive from the court for the violator to cease and desist from the unlawful neglect
Because
of their duty, Your Honor.
the council, because if we issue the privilege of the writ, no, and therefore we will tell those who violate the rules, against whom will the writ be issued?
Your Honor,
There are
we-
no respondents who are supposed to be the violators.
Yes, Your Honor. It should be
It's like
directed.
it's simple as this, no? You have a company violating our environmental law, right? Probably emitting obnoxious, something that's obnoxious, and therefore violation of our environmental law. Here comes a company. The writ will be issued against the company that's violating the environmental law. Here, you want the writ of kalikasan to be issued against a public official. The public official is not violating our environmental law. According to you, they are neglecting their duty to enforce the environmental law.
Yes, Your Honor.
Okay? Now let's go to continuing mandamus. The law is very clear, no? Unlawfully neglects its duty. We anticipated when we were drafting these rules that if we do not place unlawfully neglects, then mere negligence, the public official will be the subject matter of continuing mandamus, because there is a difference between mere negligence and unlawfully neglecting its duties. So, can you show, based from your evidence, that the public officials unlawfully neglected their duty in enforcing the environmental law? There is no judicial affidavit to prove that in the petition. So what shall we do? I think the rule is very clear. Unlawfully neglects is not only mere negligence. So that the respondents could have also submitted their evidence to show that probably they were negligent, but they did not unlawfully neglect their duties. That's why we anticipated that all of this may be factual, there may be, all of this may involve factual issues. That's why we required that these cases should also be brought to the Court of Appeals, because the Court of Appeals is a court where it can receive evidence, not the Supreme Court. The Supreme Court was only included there because we do not divest the Supreme Court of jurisdiction of any case that may be brought before any other court. That's why the Supreme Court is included there as a forum where the petition may be filed. But all if the issues are factual, we cannot receive evidence here and require the parties to testify here and then cross-examine.
Yes, Your
Huh?
Honor.
And then because of the urgency, we require that this petition should be resolved within 60 days. I hope the Solicitor General will not dispute the facts, as you have stated a while ago, because the moment that they will dispute the facts, who will now resolve that the evidence of the petitioner is more credible than the evidence of the Solicitor General? Who will now resolve it?
Yes, Your Honor.
Now, okay, you put that in your memorandum.
Yes,
no?
Your Honor.
That is my opinion, no? So may I ask Attorney Jokno to take, to take the podium, please. Now, is there a difference between a petition for writ of habeas corpus and a petition for writ of kalikasan?
Yes, Your Honor. The elements are
Of course, the
different.
difference is that in a petition for habeas corpus, it pertains to liberty, freedom, no? This one is environmental right. But in the procedure, there is a slight difference. Is it not? Because in a petition for writ of habeas corpus, the public officials who are detaining a certain person will have to make a return and then bring the person, no, before the court and justify the detention. In other words, it's easy to prove if the detention is legal or not, because if the detention carries with it a warrant of arrest, then that's it. The petition perhaps will be dismissed. But if the defendant, if the subject matter of the petition, if the person being detained, the public officials cannot show proof that the detention is legal, then the court will immediately issue the release, because there is no requirement, there is no valid reason why he should be detained, right?
In cases where there is a warrant of arrest, Your Honor, then it's very simple.
Yeah, that's why it's
adjudication
very
for the court.
simple.
But if there are conflicting allegations as to the legality of the warrantless arrest, then it would be incumbent upon the court to make the determination
yes, I agree with you, but
whether the arrest was lawful or not.
it will be easy for the court to determine. Because if they cannot show that the person arrested, there is no basis to detain through documentary evidence, wala na release na yun Yun ang petition. In the writ of kalikasan is different We only use the writ just to tell you this, because I was a member of the committee that drafted the rules. The reason why we used the writ is that we wanted to make we wanted that all these petitions must be resolved at the earliest possible time. Because if you require a comment, then it will take time for another party to file the comment, because it may ask for extensions. That's why we said that it should be a writ, and then return the writ through a comment without any motion for extensions. So that's one of the reasons why we call it a writ, to make it fast, no? But of course there are similarities, but as I said, there are also many distinctions. Now, the other thing that I would like to ask you is that it is only the Philippines that we have writ of kalikasan, right?
Yes, yeah.
You know why? Because it's only in the Philippines where the Constitution allows the Supreme Court to promulgate rules in the enforcement of constitutional right. You do not find that in any country in the world. It's only in the Philippines. That's why the Supreme Court is authorized to promulgate rules pertaining to the enforcement of constitutional rights. And we have to be proud of that. Are you aware of that? I know you're aware of that. Just to tell you that we are fortunate that we have that power, because we do not need to go to Congress and then ask for or request for a bill to be passed to become a law later on, insofar as the enforcement of constitutional rights are concerned.
Yes, Your Honor.
Okay. Now, Yes? Okay, anyway, I'm through with my, interpellation. Thank you, Dean.
Thank you, Your Honor.
Thank you very much. Thank you, Chip. That's all for me.
Okay, can I call Attorney Palacios, please? Good afternoon,
Afternoon, Your Honor.
Counsel. Yeah. In respondents' return of the writ of kalikasan, they mentioned that the DENR has been implementing numerous programs and efforts to protect the West Philippine Sea, even prior to the issuance of the writ of kalikasan. Did you
Yes, Your
read
Honor.
the writ,
Yes,
the
Your Honor.
return of the writ? Yes. Now, do you contest the veracity of the information stated in the return regarding the specific efforts conducted by the government to protect the West Philippine Sea?
We don't, Your Honor. In fact, we appreciate the continuing efforts of the respondents to protect the West Philippine Sea. However, Your Honor, the petition pertains to very specific acts which happened in 2012, 2013, and 2014, Your Honor, and we are referring to those specific acts.
And you do not have any evidence of any incident that occurred from 2015 up to 2019?
We did not include them in the petition, Your Honor, those succeeding incidents.
Because you merely relied on the findings of the arbitral tribunal.
Yes, Your Honor, we wanted to avoid issues of fact, and we relied on the official acts of the executive branch, which would be a matter of judicial notice.
Now, one of the requisites for a writ of continuing mandamus is that the respondent unlawfully neglected the performance of the duty enjoined by law. Do you agree with that?
Yes, Your Honor.
On the other hand, one of the requisites for a writ of kalikasan is that the actual or threatened violation arises from an unlawful omission of a public official or employee.
Yes, Your Honor.
Now, do you think that there is still unlawful neglect or an unlawful omission on the part of the government to protect the West Philippine Sea, despite all the programs and recent efforts that respondents have stated in the return?
Yes, Your Honor. Thank you for that question. The respondents have shown great effort to enforce laws in the West Philippine Sea. However, Your Honor, our petition pertains to very specific matters, and that is the prosecution of criminal offenses which happened in 2012, 2013, and 2014, Your Honor. And the return, Your Honor, although we specified it in our petition, the return, Your Honor, fails to respond to those allegations where we say that there was failure to prosecute these environmental crimes which happened in 2012, 2013, and 2014, Your Honor.
So to you, the adequate performance of one's duties refers to the duty to prosecute?
Yes, Your Honor. We cite, Your Honor, the provision in the in Article 2, Section 16 of the Constitution, which imposes a duty on the part of the state to protect and advance the people's constitutional right to a balanced and healthful ecology, which, Your Honor, is operationalized by the Fisheries Code provision in Section 65, Paragraph Z, which imposes a duty on BIFAR, Your Honor, to initiate criminal prosecutions for violations of the Fisheries Code. So therefore, Your Honor, there is a positive duty on the part of respondents.
Right. Now, we all know that the writ of continuing mandamus can only enjoin the performance of ministerial acts and not discretionary acts. Now, do you think that the duty to prosecute these Chinese fishermen for their alleged violation of the Fisheries Code, as well as to restrain the alleged construction building activities in the Panganiban Reef, is ministerial in nature?
Your Honor, it involves discretion, Your Honor, to determine, for example, on the part of the Department of Justice, the existence of probable cause, which would justify the filing of a criminal information. On the part of the Fisheries Law Enforcement Officer, Your Honor, it may involve discretion as to whether or not crimes were committed. However, Your Honor, the evidence submitted by the executive branch in the international arbitration characterizes these acts committed by foreign poachers as violations of Philippine law. And so therefore, the respondents themselves admit that there were criminal violations of fisheries, Philippine Fisheries Code, and therefore, Your Honor, what we are requesting is that they proceed with their obligation, which is to prosecute these criminal violations. And so therefore, Your Honor, we submit that the privilege of the writ of kalikasan may still be granted to compel the exercise of the discretion. As to how it is exercised, that is up to the respondents, Your Honor.
Would you not consider the fact that in light of the political complexities surrounding the West Philippine Sea, this duty to prosecute can become a discretionary act on the part of the government officials?
Well, Your Honor, we are mindful of the foreign policy issues in the West Philippine Sea. But however, we believe that this is a mere enforcement of domestic law in the same manner that we enforce the Fisheries Code on Filipinos. We should also enforce the provisions of the Fisheries Code on foreigners, whatever their nationality.
Okay, now in their return, respondents claim that the protection of the West Philippine Sea transcends mere enforcement of environmental laws and that the actions demanded in the petition fall within the conduct of foreign relations and are political in nature. My question is, do you think that China's persisting claims, despite the issuance of the arbitral decision, which of course China does not recognize, reasonably restricts the government's ability to fully and strictly enforce our environmental laws over the territories in dispute?
Yes, Your Honor. We follow the dualist approach where the claims of China with regard to its entitlements under the international law are operating within the international legal system. We, however, Your Honor, are here before the Supreme Court invoking domestic law within our Philippine legal system. And under the Philippine legal system, the executive branch has a constitutional duty to ensure that laws are faithfully executed. And there is also a statutory duty to initiate criminal prosecutions, Your Honor.
And the enforcement of the environmental laws is, should be done regardless of the risk of international conflict with a military superpower?
Your Honor, the enforcement of Philippine laws would be on private individuals, Your Honor. They would not be on foreign government ships. And so therefore, the positive action that we are seeking would be for public respondents to initiate criminal prosecutions as required by the Fisheries Code. And this would not entail any armed conflict, Your Honor, between Philippines and some foreign government.
But how can the government prosecute when you did not even implead the persons responsible as indispensable parties to the case?
We believe, Your Honor, that the duty is on the part of government to prosecute those who committed the environmental crimes. We did not impede them, Your Honor, because we do know where they are. However, Your Honor, if you look at the submissions, the annexes of the Philippine government submitted as part of the Philippine Memorial, the respondents were able to identify the hulls, the hull numbers of the fishing vessels, and therefore they have a way of identifying who these are. We, however, Your Honor, the petitioners, have no way of identifying who the private respondents are.
Now, the intruders into our shoal, are you definite that they are Chinese? Or they can even be Malaysians, Vietnamese, or even Filipinos?
Your Honor, we are for the fair enforcement of the Fisheries Code provisions protecting the marine environment. And therefore, they should be applied regardless of the nationality of the offender, they be Filipino or foreigner.
Now, with respect to these island building activities in the Panganiban Reef, do you have any evidence to prove that they are continuing up until today?
We don't have evidence, Your Honor, that they are continuing. However, the result of the construction of the artificial islands required the dredging and destruction of the coral reefs. This, Your Honor, is part of the expert report of Professor Carpenter, which was submitted also as part of the annex to the Philippine Memorial.
That would be all. Thank you,
Thank you,
Tony
Your Honor.
Palacios.
Justice Reyes.
College of Law. So I'll go ahead of Justice Abdelesa. Counsel, do we have lawyers, do we have soldiers at the Ayungan Shoal?
We have soldiers, Your Honor, I
Yes,
think near
stationed
there,
there?
Your Honor. Yes, we have the BRP Sierra Madre, I think, which is
And does
Beach
the
there.
Philippine Navy or the Coast Guard would send patrol boats there?
My information, Your Honor, is based on news. I understand that we try to resupply the soldiers, the Marines who are stationed in that ship, and we understand that they are encountering problems in the resupply, Your Honor.
So, if you look at the management of a country, don't you think the Philippines has complied with enforcement if they have already stationed soldiers in that area? Those soldiers' job is to guard. So, placing a guard there or a soldier is already enforcement of our border laws because they're there to protect. Is that correct?
Yes, Your Honor. Enforcement requires many actions, including the prosecution of the criminal violations, Your Honor.
No, but we're just asking about enforcement, all right?
Yes, Your Honor.
So the government has complied with enforcing our border laws or island laws, whatever laws you're quoting.
Yes,
And
Your Honor.
if you send patrol boats there once in a while, aren't you complying with enforcing the law?
Yes, Your Honor, that is part of enforcement
So
action.
we should dismiss this petition because the government is enforcing the laws.
Yes, Your Honor, we are actually focusing on very specific incidents which happened in 2012, 2013, and 2014.
But that is part of the old administration. Why did they not do that before?
Yes, Your Honor, the refusal to prosecute continues up to today, Your Honor.
Are there affidavits?
Your Honor, Your Honor,
Because
we-
this is a writ of kalikasan. This is regarding enforcement of laws. This is not regarding the prosecution of a case. This is different. I think it's a wrong petition. But you know, I was in Marinduque yesterday. I arrived, and there was traffic. There were no policemen. But I'm sure they have assigned a policeman there. So if you ask the mayor or the police chief, he will tell you, I have done my job, I have assigned policemen there, but maybe they left. So how can you tell the government now that they are not doing their job in enforcing maritime laws or fisheries laws there in that Iyungan Shoal or whatever area you're referring to?
Yes, Your Honor. The petitioners appreciate the effort of the respondents in enforcing Philippine laws in the entire breadth of the exclusive economic zone. What we are submitting, Your Honor, that they also have the obligation to prosecute the environmental crimes which they witnessed. And they recorded
Are there
in official
names
government
mentioned
records.
in those violations?
Pardon? Sorry,
Are
Your Honor.
there persons indicated who have violated these laws? Are they identified?
They were not named, Your Honor, which is, however, the fishing vessels which they occupied were named.
Are
which is why
are they identified to be of what country?
Yes, Your Honor.
So what is there a need to go after and you can't file a case without a name of a person.
Yes, Your Honor.
You cannot say I'm filing a case against the owner of a boat. So how can you really, as I said, how can you enforce something when you are trying your best to enforce? You have to remember we only have 7 boats that are capable of long run in the high seas.
Yes, Your Honor.
And we don't have adequate Coast Guard ships. We have ordered 2 from South Korea. They haven't arrived. Perhaps you might look at the monitoring of intrusion, but monitoring intrusion is different from enforcement of intrusion because we don't have the manpower or the physical assets to enforce an enforcement of an intrusion. You could have satellite photos of intrusion, but how can you really arrest these people? We are 7,100 islands, and we don't have the money, I think, resources to have a ship there every minute of the day. If you go to this part of the sea, they will fish at the other part of the sea. By the time you go to that part of the sea, since you only travel at 50 knots, by the time you get there, they're gone. So it's not an easy thing to enforce. So that's why I just feel sad that you're asking for enforcement, and I just feel sad that our country though it wants to enforce our laws, we don't have enough money. You know, we cannot even pay our soldiers, our policemen properly. And here we are demanding that we enforce something in the high seas, and you don't even peg the value of how much are stolen from our fishes. How much is stolen every day from Ayungin Sol? Do you know?
I don't know, Your Honor.
So if they're only stealing 500,000, are you going to spend 5 million of gasoline for our airplanes and everything to do that? Or would you just allow the executive to manage the economy in the country as it fit? If we have money to buy all these ships, can we not spend the money to just rehabilitate Pasig River and spend 20 billion in Pasig River so that we have enough water, instead of spending 20 billion to buy all these modern ships with all these monitoring capabilities and perhaps aggressive equipment to defend this country? So I think we should allow, as mentioned, we cannot micromanage the economy or the country. We are only here to look at the cases, but we cannot interfere nor intrude on the powers of the management by the President of the Philippines. If he deems it necessary, he can only send 10 soldiers to Ayungin Shoal because he needs to send the soldiers to other parts of the country. That's his prerogative. That's his management style. In the same manner that if I have the money to purchase ships, I just spend the money on rehabilitating Pasig River, which I feel everybody, maybe 20 million of Manila will benefit. You know, so we cannot interfere in the management of a country. And I'm just saddened that, you know, it's embarrassing that even discuss these things, because your petition really falls down to the basic fact that we are not yet a well-developed country. And the way your petition is drafted, it's as if we are the USA, that the government can attend to every problem of the country. You know, it's really, you know, sometimes I feel it's motivated to embarrass our country, this petition. Because even if we say yes, how can the government guard that shoal 24 hours a day and spend money on that when we have other important things to do in this country? That's my only thing. I think if you said that there are soldiers there in Ayungin Shoal and there are patrols sent by the government once in a while, I think they have enforced and they have already complied with their duties as the executive department, or even the duties of the Philippine Navy or the DENR or the Coast Guard. Thank you.
Thank you, Your Honor.
May I request Attorney Jokno to please take the podium.
Good afternoon, Your Honor.
Good afternoon, Counsel. The decision of the arbitral tribunal, how would you characterize it? It's what kind of a win is that?
I'm sorry.
Is it a small win?
No, I would say it is quite a victory, Your Honor.
How much of a victory? Small, big, medium?
Big victory.
Big. Historic?
Yes, Your Honor.
Astounding?
I suppose so.
Epic, according to the Chief?
Epic.
Well, it was all of those, because I think the government then brought the case to have some clarity on then very unclear positions of international law. And it is said by scholars that indeed the win brought a lot of clarity on issues pertaining to disputes in the South China Sea or in the West Philippine Sea. And if I may just refresh your memory, the tribunal ruled, if you will remember, that China's so-called nine-dash line is contrary to UNCLOS and has no basis in law. Right?
Yes, Your Honor.
So that's a big win. That the finding also that Ayungin Shoal and Panganiban Reef are within the Philippine EEZ, right?
Yes, Your Honor.
Which means that the areas within this EEZ, the sovereign rights to exploit marine and non-life resources in the seabed belongs exclusively to the Philippines, right?
Yes, Your Honor.
That also the tribunal ruled that no maritime feature claimed by China generates an EEZ, right?
Yes.
In plainer terms, this refers to Ito-Aba.
Yes, Your Honor.
Ito-Aba does not generate any EEZ to reach or threaten our reed bank, right?
Yes, Your Honor.
That's a big win, right?
Yes.
There was a finding that China has unlawfully prevented Filipino fishermen from engaging in traditional fishing in Panatag, right?
Yes, Your Honor.
Also, that China has violated its obligations under UNCLOS to protect and preserve the marine environment in the South China Sea,
Yes, Your Honor.
right? And finally, that China has constructed artificial installations and structures in Panganiban Reef without the authorization of the Philippines.
Yes, Your Honor.
So, I agree with you. All of these are very significant wins, right? And it seems to me one of the challenge that this is something that all Filipinos should be proud of, right?
Yes, Your Honor.
And a lot of Filipinos put in a lot of hard work to earn this victory. And now one of the challenges that we have is how to enforce this victory, right?
Yes, Your Honor.
Some parties have sought to enforce this by hailing China to the International Criminal Court,
Yes, Your Honor.
right?
That's
On the theory that the environmental degradations committed by China, as found by the tribunal, constitute crimes against humanity.
That is correct, Your Honor.
That's one way to enforce it, right? The present government seems to be enforcing this through bilateral negotiations with China.
Apparently, Your Honor.
Yes. Bilateral rather than multilateral.
Yes, Your Honor.
So that's another way to enforce it. Now, the IBP, representing the lawyers of the whole country, you are before this court now, obviously in an attempt also to enforce this historic win, right?
No, Your Honor. I would beg to disagree. We are simply after the enforcement of Philippine domestic law as far as the environment is concerned by Philippine agencies.
Yes. In other words, that is why between you and Counsel Rads Palacio, you keep invoking. In fact, the centerpiece of your argument is the arbitral tribunal. You are trying to enforce the tribunal through municipal law of the Philippines.
I would clarify that, Your Honor. We are invoking the admissions made by the government in the memorial submitted to the arbitral tribunal, as well as the findings that the arbitral tribunal arrived at on the basis of those submissions, but we are not asking for the enforcement of the award itself. We are citing those findings because since they came from the government, they cannot be disputed by the government. They are official reports, a matter that this court can take judicial notice of, and which will dispense of the need for reception of evidence.
And I agree with you, at least I agree with you personally, that indeed the tribunal's decision is a matter that this court should take judicial notice of, because it is a decision that this government sought.
Yes, Your Honor.
It is a decision that the Filipino nation sought
Yes, Your Honor.
in the name of the rule of law, right?
Yes, Your
And
Honor.
therefore, we are bound by it. And it's a good decision
Yes, Your Honor.
under international law. And the environmental violations there, you're saying, happen to be also violations of Philippine law,
Yes, Your Honor.
right? So that is what I mean, that you're in effect trying to enforce the tribunal's decision via Philippine law in terms of a writ of kalikasan and a writ of continuing mandamos,
Yes, Your Honor.
in that sense. Right?
Yes, in that sense.
Now, counsel, especially you, and I'm sure between you two counsels, in effect, what the IBP is trying to do is in the public interest to bring this suit on behalf of the Filipino nation, right?
In effect, yes.
Yes, that is what you call public interest litigation.
Yes, Your Honor.
And you're very familiar with it because you're a long-time practitioner of public interest litigation, especially before the court.
Yes, Your Honor.
And that's a very noble pursuit, counsel, to devote much of your time, if not all of your time, in public interest litigation.
Thank you, Your Honor.
And the two of you as such practitioners, of course, you're very familiar with the writings or the books of Neyer and Jack Greenberg.
A bit, Your Honor. I
Yes,
wouldn't
these
say
are
I am an expert.
the gurus of public interest litigation in the United States. Judicial process and social change, bringing about social change through litigation. And that's what you're trying to do. You're trying to influence the way this government will act with respect to problems in the South China Sea through litigation, right?
Yes, Your Honor.
But as Neyer reminds, when you bring a case to this court, in the name of the public interest, you seek a certain outcome, right?
Yes, Your Honor.
And you have to follow a certain process.
Naturally, Your Honor.
Because
yes.
you go to a court of law, you have to follow a process which is the judicial process.
Yes, Your Honor.
And this is where Justice Peralta comes in. And I'm afraid that despite your noblest of intentions, I agree with him that I have process problems with the kind of suit that you have brought with or to this court. The government has argues that your petition fails to state a cause of action. Now, I will not repeat anymore what Justice Peralta has said. With the permission of the Chief Justice, I will just add that the rule on kalikasan and continuing mandamos was promulgated during the term of Chief Justice Renato Puno, and three of the drafters, among them were now Chief Justice Bersamin, Justice Peralta, and the recently retired Justice Presbitero Velasco. That is why when Justice Peralta speaks about the history, the intent of the rule of kalikasan, I pay a lot of attention. And as I said, I will not repeat what he said. But just to illustrate, may I request you to please refer to paragraph 71 of your petition.
Yes, Your Honor. Paragraph 71.
Do you have paragraph 71?
Beginning with the words Chinese fishermen. Yes, Your Honor.
If you Chief, permission to read the paragraph. It says, Chinese fishermen harvested endangered and threatened species and use cyanide and explosives in their fishing. Foreign entities engaged by Chinese authorities constructed and damaged coral reefs in the process. The marine environment and resources in the above-mentioned areas were damaged severely and extensively in spite of Philippine laws to protect them. Clearly, the damage is brought upon by lack of enforcement of Philippine environmental laws by respondents.
Yes, Your Honor.
Now, this, to me, again, and unless you can convince me otherwise, in a nutshell, explains the points made by Justice Peralta. Well, Chinese fishermen harvested threatened species and cyanide and explosives. I will take judicial notice of this because this was a finding, but based on 2012 incidents. Foreign entities engaged by Chinese authorities constructed damaged coral reefs in the process. Again, based on 2012 and 2013 incidents as outlined in the decision of the tribunal. The marine environment and resources in the areas were damaged severely and extensively in spite of adequate Philippine laws to protect them. Again, I will take judicial notice. As Counsel Palacio says, you should read the testimony of Carpenter. It's a very compelling testimony about severe, irreparable damage to the environment as of July 2016. Now, your next sentence, clearly, the damage is brought about by lack of enforcement of Philippine environmental laws by respondents. That last sentence is what could be said to be a big cognitive leap. From your premise about acts done in 2012, 2013, and 2014, you take a big leap and saying clearly, therefore, the damage in 2012, 13, 15 is brought about by lack of enforcement by respondents. Respondents who came into the government in 2016. So what I am missing in amplification with the permission of Justice Peralta is you don't even allege that the damage is continuing. You don't allege it. I cannot find anything here that says the violations are continuing. Not only You have no allegation, you have no judicial affidavits. And then you blame now officials who came only in 2016 for all of those acts that happened that were damaging to us very severely, but they happened before these officials came in. So in my book, and as the government is arguing, your petition fails to state a cause of action. And failure to state a cause of action is not a technical matter. It is a matter of due process of law. If you do not even state accurately what the cause of action is, it should be dismissed. Why? Because you deprive the respondents of the ability to answer. Your allegation is lack of enforcement. What does it mean? You're not alleging, you do not allege ultimate facts. What is it that they did not do? Who did not do what where? You have no allegation, much less judicial affidavit. And now you say these officials failed to initiate criminal prosecutions. I do not find any allegation to that effect in your petition. Or your petition says it states the conclusion that there was lack of enforcement.
If Your Honor, please, the respondents were impleaded because they are those occupying the positions now. The respondents were sued in their public capacity as the heads of their respective agencies. The omissions or the violations that were committed as alleged in the petition should have been the subject of some sort of action at the very least by the government, if not by the past administration, then by those who succeeded them.
The past administration, 2012, 2013, up to 2015, that is still the past administration. Are you saying now that the officials, the counterpart officials of the past administration were equally unlawfully neglecting their duties?
To our knowledge, if Your Honor, please, no cases, not even investigations, were done by the government speaking as the state, whether this administration or the previous administration, for the violations that the government itself brought to the arbitral tribunal when they filed their memorial in 2014 and subsequent submissions in 2015.
Can I have it again, Counsel? What are you saying, that the officials, the counterpart officials of the previous administration also failed to do something about all of those incidents in 2012, 2013, and 2015?
As far as the prosecution of those responsible are concerned, Your Honor.
As far as the...
Prosecution of those responsible are concerned.
So, who brought the case before the tribunal, Counsel?
The Philippine government.
The Philippine government. And who formed the part of the Philippine government who prepared the case so that we have a case in the tribunal?
The Executive Department, Your Honor.
And specifically, your exhibits, I think, you're citing there, the BFAR, the Navy men, they all brought this case because, as the government says, people cared to get affidavits. People in the OSG cared to get the affidavits of the fishermen, the BFAR, the Navy, and brought them to the tribunal. That is not enough for you?
As far as enforcement of local laws are concerned, the Fisheries Code, Your Honor, that would not be sufficient.
Oh, that will not be sufficient. Then why did you not implead them as respondents?
Because they no longer sit, Your Honor, please, and it is the respondents now who are occupying
But don't,
those
if you are
positions.
correct, don't they, when they unlawfully were short of their duties, don't they have a responsibility to the Filipino people?
Yes, Your Honor, but if we were to file it against them in terms of a writ of mandamus or kalikasan, They would simply say that they are no longer occupying the position.
What
have
about
no
damages?
authority.
Do you want to sue them for damages because they fell short of doing their public duties?
That would be up to those who suffered the damages, Your Honor.
Well, who suffered? I thought you're taking this as a public interest litigation. You, the IBP, is representing the Filipino people.
Yes, Your Honor. But as far as damages are concerned, that is not something that the IBP is after.
Now, you cannot, the IBP, when you plead, you cannot even name that China is the one responsible for all of the environmental degradation. Do you have an explanation for that?
It is already part of the findings of the arbitral award that more than 99% of the coral reef destruction in the Spratlys were caused by Chinese vessels.
Not only Chinese vessels, the tribunal, if you read the dispositive, it is Chinese flagged vessels and Chinese vessels protected by China. So it is very explicit, China is responsible. I am wondering why you cannot even name. Your allegations gingerly go about Chinese authorities. The tribunal was very clear. China, as a state, was responsible. So I wonder why you cannot even name China. And then why are you not naming private respondents?
Well, the persons who have committed those violations were Chinese nationals, perhaps under the protection, in some instances, of Chinese government vessels, but in other instances not, Your Honor.
Now, the other part of due process, counsel, is that you do not also allege ultimate facts about what is the type of relief that you want. You now say failure to prosecute. You are not putting it as part of your relief. Your relief is very vague. You just say writ of kalikasan. And then what Justice Marvick just said, what exactly do you want? What type of action do you want from all of the respondents that you have named?
Well, definitely, Your Honor, given those violations which have been documented, the vessels identified that further investigation be done and as much prosecution as can be.
So, one is to investigate. How long do you think should the investigation last?
For as long as the prescriptive period has not lapsed, Your Honor.
Why do you have to investigate when the tribunal already said in a case brought by the Philippines that China is responsible for the artificial islands in violation of law? What do you need to investigate?
The identities of those responsible for the violations of Philippine law, Your Honor.
It's the Chinese state.
Not
Per the
necessarily.
tribunal. Read the decision very carefully.
As far as the construction, yes, Your Honor, that is.
And that's the continuing part, the construction. It severely, irreparably damaged our coral reefs. And yet, you are not charging China.
In a writ of kalikasan, Your Honor, I do not know how we could obtain jurisdiction over
And if you cannot obtain jurisdiction, why are you now faulting the Filipinos? What is the Secretary of Natural Resources supposed to do? You are saying he did not issue the environmental impact statement precisely because China went ahead and built without an environmental impact statement. The tribunal's decision is they did it without authorization. What is the DENR secretary supposed to do?
insofar as the
building, the Panganiban Reef structure, artificial island, severe, irreparable degradation to the coral environment, according to Professor Carpenter. What is the DENR supposed to do?
declare those structures illegal and take necessary action to have them.
And if we say now declare it illegal, and he declares it illegal, you want something more, and do what more?
To the extent possible, enforce the.
What to the extent possible? What?
given whatever the government is capable of enforcing.
That is my problem, Counsel. You're not telling us what exactly you want them to do. No, you're saying to whatever extent is possible. If we grant the continuing mandamus, and the order is you enforce what you need to enforce, and then you come back to us and say, by the way, Your Honors, they're not doing exactly what you have in mind. So I'm asking you now, what do you have in mind with respect to the Panganiban Reef? What is the DENR supposed to do?
Well, number one, Your Honor, would be to document what is happening there.
You don't need to document it. Carpenter. That's why I read Carpenter's testimony. Severe, irreparable injury to the ecosystem. They destroyed the ecosystem in the reef. You don't need study. You bring this case. I'm telling you the judicial notice. We will take judicial notice of that. The harm is there. Now tell me now, what is the DENR Secretary Simato supposed to do?
Well, precisely, Your Honor, the question we have as well is, what has the DENR Secretary done, given that it's very clear that this is destroying the environment and affecting not only that area, but the entire ecosystem?
That's not fair, Counsel. You seem to be asking for an advisory opinion from this court about who is going to say now what he is supposed to do. You are the one bringing the case to this court. And now you're throwing back the question to us. You want us to define what he is supposed to. You are the one petitioning to us, Counsel.
If Your Honor, please, we have, in addition to the construction.
No. Stay with the construction and stay with Simato. Because the same question will be pertinent to all the others. What is the DENR Secretary Simato supposed to do?
Work with the other agencies of government to prosecute those or to enforce the law as far as the West Philippine Sea is concerned, including those areas with the...
To prosecute who?
Whoever is responsible, Your Honor, for those.
And if he says, well, I don't know who to prosecute,
then they should work hand in hand with the armed forces, with the Coast Guard, the PNP Maritime Group, BIFAR, to find out. And
but
then,
I'm telling you already, the tribunal said it is China. It is China who constructed it. So what do you need to find out?
we want to see the laws of our country enforced.
No, again, but if that's the order, you, Simato, Secretary, make sure you enforce the law. Then he will come back, the soldier will say in the report, we have enforced the law, we are studying this thing and that thing. And then you will come back to us, will that satisfy you? What will he do that will satisfy you?
Make proper representations with the chief executive to ensure that these laws are faithfully executed. So,
with respect to all of the respondents, if they certify to you, the government through the Soldier certifies to you that they already made representations to the chief executive to enforce, they will have discharged their duties?
That is insofar as the illegal construction is concerned, because that is according to the award done by the Chinese government itself. As far as the private Chinese nationals who have committed offenses, then all agencies of government, including BIFAR, including DENR, should go after them.
Your prayer, therefore, is the court to order all the respondents to make the proper representation with the chief executive to do something about the problem.
Not as far as the other violations are concerned. Yeah.
Well, with respect to the other violations, specifically what?
The harvesting of giant clams, the destruction of the reefs not connected with the illegal structures.
But what specific relief do you wish the court to grant you?
That there be an earnest effort on the part of the government to go after the private individuals who are responsible for committing these offenses.
So we give you we give an order. You respondents do all earnest efforts with all due deliberate speed to address the problem. That will satisfy you? Because this Solgen will have a return. Your honors, we have done with all the deliberate speed, all that is necessary and within our capacity to do so. That will satisfy you?
If you look
That is the problem being posed by Justice Leonen. We give a writ of continuing mandamus like that. How often will you be going back and forth to us? Unless I'm saying it is your legal obligation to set down clearly what is it that you want them to do. Otherwise, this will become a running, never-ending process where every time you say they haven't done this, they all then will just say, we have done it, and then what? We hold a hearing again?
we will
The lack of specificity, that's what I'm saying, is not a procedural matter. That is why, even in an ordinary lawsuit, you have to be specific about even the damages and how much and what type. You cannot just say all damages. You need, because you have a different yardstick for moral, actual, exemplary, temperate, and all of that. Otherwise, you cannot just say because he harmed me, therefore it's up to the court. So it has got to do with due process. This is not about, these are not procedural. It goes to the heart of you are not being fair to the respondents if you don't outline clearly what are they supposed to do. I will just cover it in your
I will
memorandum.
cover it, Your Honor.
Thank you, Chief.
Justice Kagiwa.
Inasmuch as Justice Francis has asked almost all of my questions, maybe I can ask my questions to Attorney Raj so that it will seem as if I'm asking it for the first time. I just have a few questions.
Thank you,
They're
Your Honor.
clarificatory more than anything else. The findings of the arbitral tribunal on which you anchor your petition, to whom do they refer?
But, Your Honor, we are anchoring our petition in terms of the facts alleged on the submission of the Philippine Republic and not so much on the arbitral award itself.
Yes, but the findings do refer to two countries, correct?
Yes, Your Honor.
And they refer to the two countries as state parties,
Yes, Your
correct?
Honor.
And in fact, in the fallo, or the dispositive portion of the arbitral award, and I invite your attention to Article 10, 1203B, the tribunal holds China to be liable, correct?
Yes, Your Honor.
I invite your attention to Article 10, number 12, letter C, ABC. And I will read. Finds with respect to the protection and preservation of the marine environment in the South China Sea, A, that fishermen from Chinese flagged vessels have engaged in the harvesting of endangered species on a significant scale. Letter B, that fishermen from Chinese flagged vessels have engaged in the harvesting of giant clams in a manner that is severely destructive of the coral reef ecosystem. And C, that China was aware of, tolerated, protected, and failed to prevent the aforementioned harmful activities. My understanding of this is that, at the end of the day, these findings refer to China as a state. Do you disagree with me?
I don't, Your Honor.
Okay. To the extent that your petition is anchored upon the findings of the arbitral tribunal against China as a state, does this court grant relief against a state?
No, Your Honor.
So, going back to the question of Justice Ardesa, the strategy here for you is you're trying to seek enforcement of this arbitral tribunal by invoking domestic law.
We are seeking the enforcement, Your Honor, of domestic law using the submissions of the Philippine Republic in the international proceeding, Your Honor.
All right. And the domestic law you're referring to, among others, would be the Fisheries Code.
Yes, Your Honor.
So when you said earlier, in answer to the question of Justice Bernabe, or in Justice Francis, what else do you want us to do? Your answer was to file the necessary cases.
Yes, Your Honor. To
Is that
initiate
correct?
to initiate the criminal complaints as required under Section 65, Paragraph Z, Your Honor.
So I'm looking at the Fisheries Code, and you mentioned in your petition two sections, Section 97 and Section 88.
Yes, Your
Is that correct?
Yes, Your Honor.
And it says, violation of this provision, Section 97, shall be punished by imprisonment of 12 years to 20 years. As well, in Section 88, it says, actual use of explosives, noxious or poisonous substances, etc., shall be punishable by imprisonment ranging from 5 to 10 years.
Yes, Your Honor.
Correct?
Yes, Your Honor.
So when you say that you want the respondents to enforce the law, you want them to catch these fishermen in the Chinese flag vessels, haul them to the Philippines, and charge them with these crimes.
Your Honor, we are requesting the respondents, particularly BFAR, Your Honor, to exercise its function under Section 65, Paragraph Z of the Fisheries Code, which is to initiate the criminal complaints, Your Honor.
Correct. Towards catching these fishermen, getting them from their Chinese vessels, hauling them to the Palawan court, and then imprisoning them.
Yes, Your Honor. In fact, that's one of the...
That will satisfy you.
Yes, Your Honor.
Okay. Can I invite your attention to Article 73.3 of the UNCLOS? It says coastal state penalties of violations of fisheries laws and regulation in the EEZ may not include imprisonment in the absence of agreements to the contrary to the states concerned or any other form of corporal punishment. So in other words, what you're saying is, government, you're not doing enough. You're supposed to file cases, catch them, file cases against them, and then imprison them, but you can't because UNCLOS says we can't imprison them. So at the end, we will just be impounding their vessel, which they can recover by posting a bond.
And also, Your Honor, as an alternative to imprisonment, Your Honor, would be the imposition of a fine, Your Honor.
Yes.
As a penalty.
As a fine equivalent to the vessel's value. That is what you want to happen. Is that all? I'm trying to be...
Yes, Your Honor. Yes, Your Honor.
I'm trying to understand exactly, following what my co-justices have been asking, I'm trying to understand the specifics and particulars of exactly what it is that you want to happen, that by which you will say, hey, the laws are being enforced.
Yes, Your Honor.
That is what you want to happen.
Yes, Your Honor. The initiation of
to
criminal
initiate
complaints.
criminal suits against these people in the vessels who did these things in 2012, 2013, 2015.
With the hope, Your Honor, that this will create a deterrent against continuing violations in the Philippine Exclusive Economic Zone.
Are you not asking for the impossible? 2012, 2013, 2015, for these vessels that may no longer be there, and you cannot even certify as a fact that they are still there. Aren't you asking for the impossible?
I think, Your Honor, it would still be, it would still have value that these criminal complaints be filed by BFAR if needed. It would record the criminal violations of the foreign poachers.
What criminal record do you need? You already have the arbitral award that delineates and specifies all the violations. So what more? I'm sorry, I'm not
Yes,
getting it. I'm not really
we wish to enforce Philippine fisheries environmental laws and hold the individuals accountable, Your Honor.
But they won't be accountable because you can't put them in jail.
There may be an opportunity, Your Honor, that Philippine state may acquire jurisdiction over their person, and so that would be an opportunity to continue with the criminal proceedings which were initiated by BFAR.
I used to be in the office of the president, and I know as a regular basis, there will always be reports to the president of fishermen who had been illegally fishing in Philippine waters. And as a normal, off-the-cuff, knee-jerk, cases will always be filed. But my problem is, and I think the Sojan can verify this, that continues because the executive is enforcing the law. That is their duty. But my problem now is because you've tacked everything to the arbitral tribunal's award, which really is an award between two countries, and then you're using that as an evidence. So you see, I'm not getting it. I really am not getting it. If it's a matter of just prosecuting fishermen, I think the return has already shown the efforts of the respondents in complying with environmental laws. But if you're saying that oh, that's not enough. They should file cases against the people that they found in the arbitral tribunal, those people inside the ships. Aren't you asking for the impossible?
We believe, Your Honor, there is still an opportunity to identify those individuals. The ships that committed the illegal harvesting of endangered giant clams and sea turtles were actually boarded by by agents of the respondent, and so they even had the ship hulls recorded, Your Honor, in the documents.
And towards establishing who was running those ships. And then, how are we supposed to acquire jurisdiction over them? I'm sorry?
Your Honor, it would be possible that at some future time, the Philippine state would acquire jurisdiction over their person as individuals, and therefore the criminal proceedings.
And when we say individuals, what? They're all John Does? They're all John Does. Do we know who these people were?
Petitioners don't know, Your Honor. We don't have information
I don't
whether
think it's
the
in the
respondents
arbitral
know
award.
the names.
It's not in the arbitral award either.
Yes, Your Honor.
So I'm just not getting it, Counsel. So, Chief, that's my line of questions.
Thank you, Your Honor.
Justice Hernando.
Thank you, Mr. Chief Justice. Attorney Palacios.
Yes, Your Honor.
Would you agree with me that regardless of whether there is an arbitral award rendered by the SCS, the evidence in the Philippine memorial, which would be constitutive of the annexes to the memorial, would be evidence of violations by China of our environmental laws?
Your Honor, the proceedings were brought in the international legal system, and therefore the acts of the natural persons were sought by the Philippine state to be attributed to the Chinese state. However, Your Honor, here in the petition, we are filing it within the Philippine legal system.
The point of my question is, would the Philippine memorial and the annexes there constitute evidence of violations of our environmental laws by the Chinese state, regardless of whether or not there is an arbitral award?
By the Chinese state, Your Honor, I don't think so. However,
because what you're saying is that the court can take judicial notice of these memorials because
yes, Your
they
Honor.
are official acts
Yes,
of
Your
our
Honor.
government officials.
Yes, Your Honor.
Isn't it?
Yes, Your Honor.
So, from that point, since the violations occurred in 2012 and 2013, and you are alleging negligence or omissions by our officials, then the officials concerned would not only be with reference to those who are sitting now, but even those who sat in the past administration,
Yes, Your Honor.
including then Secretary of Justice Alfredo Benjaminez Caguioa.
The respondents, Your Honor, are the offices, and therefore whoever would be the incumbents at the time.
Yes, because he was Secretary of Justice from October 12, 2015 to January 21, 2016, when he was elevated to this court. So, having been secretary or having sat as Secretary of Justice at a time when the Philippine government already had evidence of violations of our laws by the Chinese state, then it goes without saying that the officials of the past administration, having done nothing as to those 2012 and 2013 violations, should as well be made liable for damages, including Justice Caguioa.
That is not our prayer, Your Honor. The
But
prayer
theoretically, that's what's going to happen, isn't it?
that is not
Because
the
you
prayer.
are alleging continuing negligence or omission, not just by the officials of the current administration, but even those who sat in the Aquino administration. And that's where political color comes into play in all these proceedings, Counsel, which is why it's very important that we determine the evidence here based on facts. And I think we cannot escape that the petition involves determination of factual issues. And a petition for a writ of kalikasan in respect of its substance and form, requires judicial affidavits, as pointed out by Justice Peralta. Did you get to interview any one of the private individuals who are your co-petitioners in this case? For instance, the very first named petitioner, Mr. MONICO A. Abogado. By the way, is he in court?
No, Your Honor. The petitioners from Palawan, Your Honor, are in Pag-asa Island, and some of them are in Puerto Princesa, Your Honor. The officers of IBP from Palawan spoke with them, and some national officers also met with them, in fact, in Pag-asa Island, Your Honor.
All right, so the IBP represents them.
Yes, Your Honor.
And did you get to interview any one of them?
Not myself, Your Honor. The officers of IBP who went to meet with them, interviewed them, Your
Well,
Honor.
so it should have been very easy for the IBP to secure an affidavit, a judicial affidavit of at least one of them, like MONICO Abogado.
Yes, Your Honor. Our theory, however, Your Honor, is that the essential facts of the case are matters of judicial notice, Your Honor.
Well, with regard to, as pointed out by Justice Ardaleza, with regard to 2012 and 2013 violations,
Yes, Your Honor.
but what about the continuing violations that you are alleging? What is your factual evidence, counsel?
Your Honor, we may, because the petition alleges omission on the part of public respondents to prosecute specific acts which
All
have
right, Commission. Did you write a letter, for instance, to the Secretary of the DENR requesting for action on a violation of a particular individual, let's say? Did you do that?
I don't think we did that, Your Honor.
Because if you did not, then you cannot possibly allege omission on the part of that official for violating our environmental laws. I mean, in the matter of non-prosecution of our environmental laws. And what about the Secretary of Justice? Did you write any letter or corresponded with him, bringing to his attention any perceived or actual violation by a particular individual, whether it be a Filipino or a Chinese or a Vietnamese, who are violating our laws on environment? Did you correspond with him?
I'm not sure, Your Honor. I don't think we did, Your Honor.
All right. So that just goes to show that these are factual matters that need evidence, counsel, as pointed out by Justice Peralta. Did you ask, because theoretically, as I pointed out earlier, officials of the past administration could be held liable for damages for meeting to prosecute violators of our environmental laws. For instance, did you correspond with the office of Justice Ben Kagiwa and ask him whether during his term as Secretary of Justice, was he in possession of any fact that may constitute evidence of violation of our environmental laws, and did he do anything about it?
We did not do that, Your
You did not
Honor.
do that. See? So these are all factuals, factual matters, Attorney Palacios, which is why we need to see judicial affidavits. And we just cannot rest our judgment on judicial notice of officials, of our government officials pertaining to the past administration, because you are alleging continuing violation. See? And by the way, why did you not include the Secretary of National Defense as a correspondent? Because the Philippine Navy is under the Armed Forces of the Philippines, and it's the Secretary of National Defense who gets to answer for nonfeasance or malfeasance or anything of his subordinates, no? But he is not a correspondent in this case.
Yes, Your Honor. We looked at the provisions of the Fisheries Code and looked at the list of government agencies that are authorized to enforce the provisions of the Fisheries Code, and they are named as respondents, Your Honor.
And the Kalayaan Palawan Farmers and Fisher Folk Association, is this an incorporated association?
We sought confirmation, Your Honor, from IBP Palawan. We understand that they are not incorporated, and so they are suing in their individual capacity, Your Honor.
Mhm. So not as an association?
Not as an association.
All right, thank you.
Thank you, Your Honor.
I have no more questions, Mr. Chief Justice. Thank you.
Justice Reyes.
Thank you, Chief. Attorney Palacios, it just occurred to me just now that there are administrative remedies available in all government machineries, right?
Yes, Your Honor.
Yeah. Are there administrative remedies available at the DENR or any of its bureaus? In case there is violation or there is lack of, or there's inability of any of the officials to perform their duties, do you think you can call their attention and resort to administrative remedies available to the public, like you?
Yes, Your Honor. Article 138 of the Fisheries Code requires the prior notice and a period of 15 days to allow the public official to respond to the request for action. However, Your Honor, this requirement for 15-day notice is not required for petitions for writ of kalikasan. In fact, this was discussed in the case of Osmeña versus Garganera, where the Supreme Court characterized the writ as an extraordinary remedy, and to which the requirement for 15-day, or in that case 30-day prior notice, is not required, Your Honor.
Of course, the law of environmental procedure does not require the exhaustion of administrative remedies prior to the filing of writ of kalikasan or mandamos. But you know, in my lectures all over the country, you know, in connection with PhilJA, we always encourage resort to administrative remedies because this would be faster. No? Because if you look at the purpose of the writ of kalikasan, the purpose is to direct, as is stated in your prayer, to direct whoever the respondents are, including the President of the Philippines, the Secretary of the DENR, direct them to do their jobs,
Yes.
right?
Yes, Your Honor.
Now, that can be achieved without having to resort to requesting for writ of kalikasan or even mandamos. I noticed, I heard earlier that one of the things that you would like to do is to file a case for
Yes,
criminal violations, file a case. Is there a need to compel the Secretary of Justice by way of mandamos for the Secretary of Justice to file a criminal case for criminal violations against Chinese fishermen who harvested endangered and threatened species, or foreign entities who constructed and damaged coral reefs? Do you think, do you need to compel them, or do you just have to file?
Filing, Your
Criminal
Honor,
cases.
because the determination of whether the facts are sufficient to support a probable cause
All right.
for the filing of a criminal information before the court is a discretionary function of the Justice Secretary, whereas Section 65, Paragraph Z of the Fisheries Code imposes a duty on the part of the Bureau of Fisheries to initiate the criminal prosecution of violations of the Fisheries Code.
Yeah, correct. But you don't really have to resort to mandamos to compel the prosecution, right? To do something, especially if there are criminal violations. Similarly, in the case of writ of kalikasan, all you have to do is just ask the DNR officials to do their jobs. It will be faster, right? And if you look at the allegations in your petition, Attorney Palacios, it would seem that the allegations, meaning the violations, are not really clear and without any support of any factual basis, other than those stated in the decision of the arbitration. Now, as it is now, what do you think if the petition is dismissed for lack of cause of action? What will be your next move?
We have not discussed, Your Honor, the unhappy situation where the
All right.
petition will be dismissed.
Of course, we are not anticipating that the petition will be dismissed, but just in case, can you not resort to other remedies, like perhaps proceeding immediately to the DNR and telling them, why don't you do something about this?
We will discuss our options, Your Honor, once we receive the judgment.
Yeah, you should always be open to different options. Anyway, thank you very much, Attorney Palacios. Chief,
Thank you, Justice.
Sorry.
You can answer the questions, Attorney Palacios. I refer back to paragraph 71 as cited by Justice Francis. So there are two violators here. One is the Chinese authority. The other one are poachers and fishers who had harvested endangered species in the specified areas. And these were happenings before, not in the immediate past.
Yes, Your Honor.
So, and your main relief being requested from the court is to direct these people to initiate criminal prosecution.
Yeah, as required, Your Honor, by Section 65 of the Fisheries Code.
Are these people still there?
We are referring to the respondents, Your Honor, are the agencies.
Yeah, but if you're asking for the prosecution of these criminal violators, are these people still there?
We have no information, Your Honor.
So how can we prosecute them? How can any court acquire jurisdiction? How can any office acquire jurisdiction over these people if they are not there anymore? If they are not specified by names?
We are
How
hoping...
can the Department of Justice proceed with the initiation of a criminal proceeding against these people?
We are hoping, Your Honor, that the members, the personnel of the respondents who boarded the fishing vessels of the foreign poachers in 2012-2013 will have their identity, Your Honor, and therefore that would be sufficient basis to initiate the criminal complaints.
Have you found out if they listed the names?
We looked at, Your Honor, we looked at the annexes to the Philippine Memorial. We did not find the names. Instead, what we found were the hull numbers of the boats, Your Honor.
How can we, because these are criminal violations, so these are personal criminal violations, how can we get them to our courts or to our prosecutorial office if they are not identified? Because you were talking of incidents from 2012 to 2015.
Yes, Your Honor. We are hoping, Your Honor, that the personnel of the respondents who boarded the fishing vessels would have their names, Your Honor. Petitioners don't have those names.
Are they still around? Meaning these people who violated the environmental laws, are they in the area of concern?
We don't have information, Your Honor.
So how can they be prosecuted?
We are hoping, Your Honor, that the personnel of the respondents have the names of the...
So it's only a hope, but you're asking us to direct them to enforce laws, fisheries laws.
Yes,
It's
Your
only
Honor.
a hope, but you are asking the court to direct several agencies to enforce our fisheries laws.
Yes,
and
Your Honor.
one of the remedies is a criminal prosecution against the violator.
Yes, Your Honor, to initiate the criminal complaints, Your Honor.
But you don't know these people.
We don't have the information, Your Honor. We're hoping that the personnel of the respondents would have the names of the foreign poachers.
Okay. In your relief, you're asking the court to direct the respondents to protect, preserve, rehabilitate, or restore the environment in the areas. Can Can we do this?
With regard to Panatag Shoal, Your Honor, we are aware that there are ongoing discussions between Philippines and China, and so it would pose some challenges. But our prayer, Your Honor, is that for the respondents to exert efforts to protect the marine environment best as they can.
To exert efforts to protect our environment. This is an executive function. Can we direct the President or the Executive Department to do all of these things under our direction?
They have the duty, Your Honor, to protect.
But I'm asking you, can the court say, you protect this, you do this, you preserve this, you rehabilitate this, you executive, you do this. Can we do that?
I believe so, Your Honor. I believe that the Supreme Court has the power to direct those things. Your Honor.
Just a few questions.
Thank you, Your Honor.
Attorney Palacios. Is there any distinction between the present case and the remedies you are praying for, on one hand, and the cases involving Manila Bay, Laguna de Bay, and Pasig River, or the island of Boracay, and the prosecution of those who caused the degradation of these bodies of water?
Thank you for that question, Your Honor. I'm not aware if the applicable laws include the Fisheries Code, Your Honor, which has a specific provision imposing the duty on the part of BIFAR to initiate criminal complaints for violations of the Fisheries Code. But if they involve the Fisheries Code, Your Honor, then we believe that the same outcome would be desired for those other cases.
Would you know how the executive branch handled these environmental problems? Say the recent Boracay Island problem. How did the executive deal with it?
Yes. The information I have, Your Honor, is the information I only received from the news, and I understand that the area was shut down and there was some construction ongoing, and because there were no tourists allowed to go on the island, they also did some cleanup of the beach, Your Honor. But this is information from the news only, Your Honor.
Yes. And so did the executive exercise caution in resolving these problems?
I am not in a position to say, Your Honor, whether
Here.
the executive branch exercised caution. I understand that they took those measures, and I understand that the shutdown was for at least 6 months.
Yes.
So if that's a sign of caution, Your Honor, then maybe, yes, there was caution on the part of the
Caution?
executive.
That is caution? He demolished, he caused the demolition of illegal structures, and he actually issued a ban on traveling within 6 months. And then look at Manila Bay. Its cleanup is ongoing, and people are prohibited from doing leisure activities in the area. So is that a show of full political will?
Sorry, Your Honor, I misunderstood your question about caution. I was referring to the actions taken to restore
Yes.
the marine environment, Your
Yes.
Honor, not really on actions to regulate the movement of natural persons.
And did we not see immediate results
I think so, Your Honor. But again, this
on
information is
how
based on
the
news, Your Honor.
executive handled these problems?
Yes, Your Honor, yes.
Yes. So, what is the distinction between your case now before the court involving areas within our exclusive economic zone and these bodies of waters wherein the executive has immediately implemented remedies
Your
to
Honor,
the extreme, actually, even ordering the closures of these tourist destinations?
Yes, Your Honor. I think we can distinguish on 2 points, Your Honor. First is that there is an obligation in the Fisheries Code to initiate the criminal actions. And second, the violations, Your Honor, the commission of the environmental crimes were observed by public respondents and documented by them in official government records, Your Honor. So
Would you
on those 2
say that
points.
the executive stuck now with respect to these areas within our EEZ is different from the tact or the remedies that the executive has done with respect to the 3 bodies of water that are within our national territory?
Yes.
Hello? Hello? Can you hear me?
Yes, Your Honor.
Yes.
Thank you for that question. So you're asking, asking me to compare, Your Honor, the actions of the executive branch for this case and the actions with Boracay and Manila Bay and Laguna Lake, Your Honor.
On Boracay, for example, problem SWIFT.
Again, Your Honor, the information I have is just based on news, and I understand that it was a quick decision on the part of the executive branch.
All right.
Yes, Your Honor.
How about in this case? It is accepted and it is of judicial notice that the damage has been there for a long time. So, what is the reason, at least you can tell us, why do you think the President or the Executive is not as swift in dealing with this problem?
I guess I would be speculating, Your Honor, as to the reason of the President in not swiftly acting with regard to the issues of Ayungin Shoal.
Cautiously.
Yes, he's acting cautiously
Handling.
in contrast to past behavior with regard to Boracay. Maybe there's some perception, Your Honor, that it would have some foreign relations impact, Your Honor.
Exactly.
Yes. However, Your Honor,
that is the distinction.
Yes.
On one hand, the Manila Bay, Boracay, they all lie within our national territory and they are devoid of any foreign relations considerations. On the other hand, the EEZ, those situated within the EEZ, have foreign relations considerations and even national security. All right. Your task is to confront the violators, right?
the individuals, Your Honor,
Yes.
they should be subjected
Here,
to criminal prosecution.
you
Your Honor.
are proposing the filing of criminal charges against them. And that is confrontational. On the other hand, the court can also take judicial notice of how the President is proceeding with caution on this issue. So perhaps it is safe to say that the President is not opting for any confrontation because he is exhausting all available means through the diplomatic channel. Would you agree?
Your Honor, we are mindful of the foreign policy issues involved in the Philippine exclusive economic zone. However, Your Honor, here we come before the court asking for the enforcement of domestic laws. And if domestic laws with regard to environment, to protect the environment, are enforced against Filipinos, they too should be enforced against foreigners.
That's the problem. Because you cannot really separate the environmental concerns issue from the legal or foreign relations issue. They are so gelled together. You cannot tear them apart. All right. My last question is this. Is the court imbued with the expertise and competence to determine the extent of the possible damage that may be caused by the grant of this petition to our foreign relations and to the national security concerns of the country?
Again, Your Honor, we understand that there are foreign policy issues relating to the Philippine economic zone. However, we believe that this is a petition really just for the enforcement of domestic environmental laws. And diplomacy we use to discuss with foreign governments. However, with regard to individuals who persist and continue to violate Philippine environmental laws, I think we should use the tax of prosecution.
My question is this. No. Are we, the court, imbued with the capability to determine the extent of damage that may be caused by your petition, in case we grant it, to our foreign relations and national security concerns?
I'm not aware, Your Honor, of the ability of the court to determine the foreign policy implications. However, Your Honor, the respondents here are not foreign nationals. The respondents are our government agencies. And
But
what we are requesting,
you prosecuting them?
We are requesting.
You want to prosecute
yes, Your Honor.
individuals?
We ask that the respondents exercise the duty imposed upon them by Section 65
Yes,
of the
because
Fisheries
it's
Code.
a chain. You cannot break the chain without breaking the whole thing. Right. Thank you very much,
Thank you, Your
Mr.
Honor.
Counsel.
Okay, Justice Ardelesa and then Justice Leonin.
Chief, can I have counsel? Counsel, do you have a copy of the dispositive of the tribunal's
I can get
award?
it, Your Honor. Yes, Your Honor.
Counsel, can you please turn to page 476? Can you, the finding number 15?
15.
Yes, it says, the tribunal finds, with respect to the operation of Chinese law enforcement vessels in the vicinity of Scarborough Shoal, A, that China's operation of its law enforcement vessels on April 28, 2012 and May 26, 2012 created serious risk of collision and danger to Philippine ships and personnel.
Yes, Your Honor.
And letter B, that China's operation of its law enforcement vessels on April 28 and May 26, 2012 violated Rules 2, 6, 7, 8, 15, and 16 of the Convention on the International Regulations for Preventing Collisions at Sea of 1972. I guess they call it school right? And declares that China has breached its obligations under Article 94 of the Convention.
Yes, Your Honor.
Well, if you will, we do not have the time, but with counsel kindly your own time, go over the decision itself with respect to finding 15. And but in brief, and pardon, maybe a while ago I had some rapid fire questions to you. The reason I was concerned about statements relating to inadequacy of the response of officials of the previous administration is that the incident referred to in finding 15 is the confrontation between Philippine Navy and Coast Guard vessels and Chinese fishermen who were poaching and were caught red-handed by our Navy personnel poaching in our waters, harvesting clams and harvesting other endangered species. If you read the decision, our Navy personnel tried to board, tried to accost, and tried to confiscate the giant clams because this was at the mouth of Scarborough. And the account here is very gripping. Chinese law enforcement vessels, if you read the opinion, these are the so-called CMS, Chinese Maritime Surveillance Vessels. These are huge vessels, many, many times bigger than our Navy patrol boats. Look at the finding. These Chinese law enforcement vessels cut through our patrol boats. That is why the finding is they created serious risk of collision and danger to the Philippine ships who were trying to interdict the poachers, the Chinese poachers. And because of the threat of being rammed by the CMS of China, and it says here, China's, meaning China the state. This is not private vessels. These are Chinese law enforcement vessels. Our commander, our Filipino commander on the ground, gave the order for his people to withdraw. And that is why you will pardon why a while ago I got to ask you, pepper you with questions, because the bravery and valor of the people on the ground in this incident shows that maybe the Filipinos in the previous administration will also doing more than their part. So, including the Secretary of Justice then. So, I will just ask you to read the gripping account on this encounter. And explain why I acted the way I did a while ago. Thank you, Counsel.
Thank you, Your Honor. We acknowledge that, and as well the fact that we understand the reluctance on the part of the previous administration to do anything that may disturb the decision of the arbitral tribunal, which came out only in 2016. So the reason why we believe that the present respondents should take action is because the tribunal's decision is already out. There's nothing anymore there to be to cause an issue for, and we think that they should continue with the enforcement of our laws.
Thank you.
Thank you.
Counsel, just a few clarificatory questions. I think you did not mean, or your colleague did not mean, that the EEC is not within our jurisdiction in response to some questions of Justice Javier a while ago. The EEC is not within our jurisdiction. It is within our jurisdiction. Is that
Yes,
not correct?
it is, Your Honor.
As a matter of fact, even the UNCLOS acknowledges our sovereign rights, although we do not exercise sovereignty in general, but sovereign rights, in fact, even exclusive in that nature, correct?
That's very clear, Your Honor.
And therefore, it is not that these features, Scarborough, the Second Thomas Shoal, and Mischief Reef, are not within our territory. They are, correct?
Yes, Your
And anybody that claims that it is not, I think it's an impeachable offense once they claim that, correct?
Yes, Your Honor.
Just to clarify a response made by Attorney Palacios a while ago to Justice Javier, knowing the sensitivity of the transcript of these proceedings in relation to the difficulties of foreign relations that may be suffered by the Office of the President, correct? Now, would you agree with me that the writ of kalikasan or the order for continuing mandamus should not address the symptoms only, but should go at the cause of the ecological destruction as much as possible?
As much as possible.
Because you do not want to make use of this special proceeding or special civil action only to address the symptoms, such as, for instance, just going against Chinese and foreign fishers and poachers. Would you agree with me that it's like addressing the problem of drugs simply by going against retailers selling less than 1 gram of shabu? Yes, so you want a holistic approach, meaning to say that you want to go against the manufacturers, and in this particular case, you want to go against the enabler causing the ecological destruction in the area that are of our interest in this case. Is that not correct?
That's true.
And the enablers are very clear in the arbitral award. Were it not for the support of the Chinese military and police vessels, the fishers would not have been emboldened. Were it not for the presence of the artificial island, that is installation that is now in Mischief Reef, then it would be easier for Philippine law enforcers to actually enforce our Philippine laws. And therefore, isn't this petition clearly your attempt to make the Philippine government make China comply with the arbitral award?
Well, it is our attempt for our government to enforce fisheries laws.
In your view, the arbitral award is the legal basis for the government to make China accountable, correct? So is this case a way to make the Philippine government make China address the ecological damage found in the arbitral award, not merely to acknowledge, but remediate, mitigate, and prevent further damage?
Indirectly, it is, Your Honor, through the enforcement by
In which
our
case, if
agencies.
that is the issue, then therefore we don't need any expertise because you have the arbitral award, correct?
Yes, Your Honor.
And the neglect is that the Philippine government has not executed it, has not actually enforced it from your point of view. And by the Philippine government, I think you mean the president?
As head of
And you
state,
want the
yes.
president to do what he did in Boracay. He did, short of martial law, that is my dissent, he closed down an entire island. And in the entire island, he made the remediation measures or allowed his executive agencies to make the remediation measures.
No, Your Honor, I agree with Your Honor's dissent. In fact, as far as a previous question was concerned as to what
So in
our
your view,
agencies can
if
do,
the president can do that for Boracay, why can't he not do that in the West Philippine Sea? Is there something that he is afraid of? Correct?
and perhaps, Your Honor.
Okay, now, and you wish Congress to actually also move to do an investigation as to why the arbitral award is not being enforced, or to make the president as head of state accountable as to the moves he is taking in order to implement the arbitral award, correct?
That is not within the relief that we are asking.
Or that you want Congress to enforce the arbitral award to actually allocate funds for the Coast Guard and the Navy. Is that not correct?
Well,
you mentioned that a while ago.
That would be, yes, one of the
Because we have the best seafarers in the world. We have the best seafarers, but we have a Coast Guard and a Navy that is ill-equipped The men and women of the Coast Guard and the Navy are heroic individuals. We do not have the resources, yet we have the persons and the seafarers that can actually man these ships, correct? And I know for a fact that UP Visayas has naval architecture in one of its courses, and so on and so forth. Is that not correct?
Yes, Your Honor.
If you want the Philippine government to enforce the arbitral award, is this court a part of the Philippine government?
Of course.
And you want it via a writ of kalikasan and a writ of continuing mandamus. Is that not correct?
Yes, Your Honor.
But if we do that, would we not be conducting foreign policy?
I don't believe you would.
Would we not
the
be
court would
conducting appropriation of funds?
No, Your Honor.
Would we not be therefore telling the executive, here is the project plan. Here is how you enforce the arbitral award. First, you do this, then this next, and then this, and then that. Because in order for us to say that the arbitral award is enforced, you have to get China out. You have to get them out of our territory. Because the truth is, they are in our territory. They are occupying our features. They are in our exclusive economic zone. They have invaded. And we want them to find a way, we have to find a way to get them out. But to get them out is a tall order. There has to be many steps that need to be taken. You want the court to supervise all of these steps in order to actually address the ecological disaster in the West Philippine Sea?
We simply want the Honorable Court to see to it that fisheries laws are enforced in the country. We understand that we may not be able to file cases, or BIFAR may not be able to file cases against the named individuals because they don't have the identities, but at the very least, cases against them could be filed. At the very least, administrative.
But Counsel, that's easy.
Summary
Today-
fines. And
Today, I tell the Solicitor General, please tell your clients, enforce the fisheries law. I am sure he will say yes. So is that the
No,
order?
to be more specific, Your Honor, for example, the hull numbers identified by the BIFAR.
Can we interfere with prosecutorial discretion and order the Department of Justice to pursue cases against specific individuals?
At the very least, to investigate, Your Honor.
Would that not
That
mean...
would be dereliction
Yes,
of
even-
duty on their part
Yeah.
if they would not investigate, given that
You
there
mean
are...
the court can tell the police, please investigate this case? We will not be an impartial court.
If, for example, Your Honor, hypothetically, a crime were to be committed and the police were not, and they were in a position to investigate but they did not, then I believe a court could order them to conduct an investigation, not necessarily to how they will exercise their discretion, but at least to
Address this in your memoranda. Is this not a way of the petitioners, the fishers, to actually, the marginal fishers that could not come here, to tell the government, please enforce the rights that we have won. Please do not diminish it. Is this a way for the fishers to actually say so? Now, on the other hand, is this the proper way for the government to actually enforce it? Is this the proper time that the court actually comes in? Please cover that in your
Thank you, Your
memorandum.
Honor. We will do that.
All right, we are done with the petitioner side. We'll continue the oral arguments on July 9 at 2 o'clock in the afternoon to receive the presentation of the respondents. So there being no other matters to discuss